Yeah. Excellent. This is?
We'd ask all the members of the media that are taking thousands of pictures here. I'm sure they got some excellent ones of the director, but we'd ask you to please clear aside so we can begin the hearing. The Judiciary Committee will come to order, and without objection, the Chair is authorized to declare recesses of the committee at any time. We welcome everyone to this afternoon's hearing on the Encryption Tightrope, Balancing American Security and Privacy, and I will begin by recognizing myself for an opening statement. We welcome everyone today to this timely and important hearing on encryption. Encryption is a good thing. It prevents crime. It prevents terrorist attacks. It keeps our most valuable information safe. Yet it is not used as effectively today as is necessary to protect against the ever-increasing sophistication of foreign governments, criminal enterprises, and just plain hackers. We see this manifest almost every week in the reports of losses of massive amounts of our most valuable information from government agencies, retailers, financial institutions, and average Americans. From identity theft to the compromising of our infrastructure to our economic and military security, encryption must play an ever-increasing role, and the companies that develop it must be encouraged to increase its effectiveness. Encryption is a topic that may sound arcane or only the province of techies, but in fact, it is a subject whose solutions will have far-reaching and lasting consequences. The Judiciary Committee is a particularly appropriate forum for this congressional debate to occur. As the committee of exclusive jurisdiction over the United States Constitution, the Bill of Rights, and the federal criminal laws and procedures, we are well versed in the perennial struggle between protecting Americans' privacy and enabling robust public safety. This committee is accustomed to addressing many of the significant legal questions arising from laws that govern surveillance and government access to communications, particularly the Wiretap Act, the Electronic Communications Privacy Act, the Foreign Intelligence Surveillance Act, and the Communications Assistance to Law Enforcement Act, otherwise known as CALEA. Today's hearing is a continuation of the committee's work on encryption, work that Congress is best suited to resolve. As the hearing title indicates, society has been walking a tightrope for generations in attempting to balance the security and privacy of Americans' communications with the needs of our law enforcement and intelligence agencies. In fact, the entire world now faces a similar predicament, particularly as our commerce and communications bleed over international boundaries on a daily basis. Encryption in securing data in motion and in storage is a valuable technological tool that enhances Americans' privacy, protects our personal safety and national security, and ensures the free flow of our nation's commerce. Nevertheless, as encryption has increasingly become a ubiquitous technique to secure communications among consumers, industry, and governments, a national debate has arisen concerning the positive and negative implications for public safety and national security. This growing use of encryption presents new challenges for law enforcement seeking to obtain information during the course of its investigations, and even more foundationally, tests the basic framework that our nation has historically used to ensure a fair and impartial evaluation of legal process used to obtain evidence of a crime. We must answer this question: how do we deploy ever stronger, more effective encryption without unduly preventing lawful access to communications of criminals and terrorists intent on doing us harm? This now seems like a perennial question that has challenged us for years. In fact, over 15 years ago, I led congressional efforts to ensure strong encryption technologies and to ensure that the government could not automatically demand a backdoor key to encryption technologies. This enabled the U.S. encryption market to thrive and produce effective encryption technologies for legitimate actors rather than see the market head completely overseas to companies that do not have to comply with basic protections. However, it is also true that this technology has been a devious tool of malefactors. Here is where our concern lies. Adoption of new communications technologies by those intending harm to the American people is outpacing law enforcement's technological capability to access those communications in legitimate criminal and national security investigations. Following the December 15 terrorist attack in San Bernardino, California, investigators recovered a cell phone owned by the county government but used by one of the terrorists responsible for the attack. After the FBI was unable to unlock the phone and recover its contents, a federal judge ordered Apple to provide reasonable technical assistance to assist law enforcement agents in obtaining access to the data on the device, citing the All Writs Act as its authority to compel. Apple has challenged the court order, arguing that its encryption technology is necessary to protect its customers' communications, security, and privacy, and raising both constitutional and statutory objections to the magistrate's order. This particular case has some very unique factors involved, and as such may not be an ideal case upon which to set precedent. And it is not the only case in which this issue is being litigated. Just yesterday, a magistrate judge in the Eastern District of New York ruled that the government cannot compel Apple to unlock an iPhone pursuant to the All Writs Act. It is clear that these cases illustrate the competing interests at play in this dynamic policy question, a question that is too complex to be left to the courts and must be answered by Congress. Americans surely expect that their private communications are protected. Similarly, law enforcement's sworn duty is to ensure that public safety and national security are not jeopardized if possible solutions exist within their control. This body, as well, holds its own constitutional prerogatives and duties. Congress has a central role to ensure that technology advances so as to protect our privacy, help keep us safe, and prevent crime and terrorist attacks. Congress must also continue to find new ways to bring to justice criminals and terrorists. We must find a way for physical security not to be at odds with information security. Law enforcement must be able to fight crime and keep us safe, and this country's innovative companies must at the same time have the opportunity to offer secure services to keep their customers safe. The question for Americans and lawmakers is not whether or not encryption is essential. It is, but instead whether law enforcement should be granted access to encrypted communications when enforcing the law and pursuing their objectives to keep our citizens safe. I look forward to hearing from our distinguished witnesses today as the committee continues its oversight of this real-life dilemma facing real people all over the globe. It's now my pleasure to recognize the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. Members of the committee and our first and distinguished guests, I wanted to associate myself with your comments about our jurisdiction. It is not an accident that the House Judiciary Committee is the committee of primary jurisdiction with respect to the legal architecture of government surveillance. In times of heightened tension, some of our colleagues will rush to do something, anything, to get out in front of an issue. We welcome their voices in the debate, but it is here in this committee room that the House begins to make decisions about the tools and methods available to law enforcement. I believe that it is important to stay up front before we get into the details of the Apple case that strong encryption keeps us safe. even as it protects our privacy. Former National Security Agency Director Michael Hayden said only last week that America is more secure with unbreakable end-to-end encryption. In this room, just last Thursday, former Secretary of Homeland Security Michael Chertoff testified that in his experience, strong encryption laws help law enforcement more than it hinders any agency in any given case. The National Security Council has concluded that the benefits to privacy, civil liberties, and cybersecurity gained from encryption outweigh the broader risks created by weakening encryption. And Director Comey himself has put it very plainly. Universal, strong encryption will protect all of us, our innovation, our private thoughts, and so many other things of value, from thieves of all kinds. We will all have lockboxes in our lives that only we can open and in which we can store all that is valuable to us. There are lots of good things about this. Now, for years, despite what we know about the benefits of encryption, the Department of Justice and the Federal Bureau of Investigation have urged this committee to give them the authority to mandate that companies create backdoors into their secure products. I've been reluctant to support this idea for a number of reasons. The technical experts have warned us that it is impossible to intentionally introduce flaws into secure products, often called backdoors, that only law enforcement can exploit to the exclusion of terrorists and cyber criminals. The tech companies have warned us that it would cost millions of dollars to implement and would place them at a competitive disadvantage around the world. The national security experts have warned us that terrorists and other criminals will simply resort to other tools entirely outside the reach of our law enforcement and intelligence agencies. And I accept that reasonable people can disagree with me on each of these points. But what concerns me, Mr. Chairman, is that in the middle of an ongoing congressional debate on this subject, the Federal Bureau of Investigation would ask a federal magistrate to give them the special access to secure products that this committee, this Congress, and the administration have so far refused to provide. Why has the government taken this step and forced this issue? I suspect that part of the answer lies in an email obtained by the Washington Post and reported to the public last September. In it, a senior lawyer in the intelligence community writes that although the legislative environment towards encryption is very hostile today, it could turn in the event of a terrorist attack or a criminal event where strong encryption can be shown to have hindered law enforcement. He concluded that there is value in keeping our options open for such a situation. I'm deeply concerned by this cynical mindset, and I would be deeply disappointed if it turns out that the government is found to be exploiting a national tragedy to pursue a change in the law. I also have doubts about the wisdom of applying the All Writs Act, enacted in 1789, codified in 1911, and last applied to a communications provider by the Supreme Court in 1977 to a profound question about privacy and modern computing in 2016. I fear that pursuing this serious and complex issue through the awkward use of an inept statute was not and is not the best course of action. And I'm not alone in this view. Yesterday, in the Eastern District of New York, a federal judge denied a motion to order Apple to unlock an iPhone under circumstances similar to those in San Bernardino. The court found that the All Writs Act, as construed by the government, would confer on the courts an overbroad authority to override individual autonomy. However, nothing in the government's argument suggests any principal limit on how far a court may go in requiring a person or company to violate the most deeply rooted values. We could say the same about the FBI's request in California. The government's assertion of power is without limiting principle and likely to have sweeping consequences, whether or not we pretend that the request is limited to just this device or just this one case. This committee, and not the courts, is the appropriate place to consider those consequences, even if the dialogue does not yield the results desired by some in the law enforcement community. I'm grateful that we are having this conversation today back in the forum in which it belongs, the House Judiciary Committee. And so I thank the chairman very much, and I yield back.
Thank you, Mr. Conyers. And without objection, all other members' opening statements will be made a part of the record. We welcome our distinguished witness of today's first panel. And if you would please rise, I'll begin by swearing you in.
Sorry.
Do you swear that the testimony that you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you very much. Please be seated. I'll now begin by introducing our first distinguished witness today, Director James Comey of the Federal Bureau of Investigation. Director Comey began his career as an assistant United States attorney for both the Southern District of New York and the Eastern District of Virginia. After the 9/11 terrorist attacks, Director Comey returned to New York to become the United States Attorney for the Southern District of New York. In 2003, he was appointed Deputy Attorney General under the United States Attorney General John Ashcroft. Director Comey is a graduate of the College of William and Mary and the University of Chicago Law School. Director, welcome. Your entire written statement will be made a part of the record, and I ask that you summarize your testimony in 5 minutes. And we have the timing light that you're well familiar with on the table. Again, welcome. We're pleased that you are here, and you may begin your testimony.
Thank you so much, Mr. Chairman. Mr. Conyers, thank you for hosting this conversation and for helping us all talk about an issue that I believe is the hardest issue I've confronted in government, which is how to balance the privacy we so treasure that comes to us through the technology that we love, and also achieve public safety, which we also all very much treasure. I worry a little bit that we've been talking past each other, both folks in the government and folks in the private sector, when it comes to this question of encryption, which we in the government call going dark. What I'd like to do is just take 3 or 4 minutes and try to frame how I think about it, in a way I hope is fair-minded, and if it's not, I hope you'll poke at me and tell me where you think it's not. But these are the things I believe to be true. First, that the logic of encryption will bring us, in the not-too-distant future, to a place where all of our conversations and all of our papers and effects are entirely private. That is, where no one can listen to our conversations, read our texts, read our emails, unless we say so, and no one can look at our stuff, read our documents, read things we file away without our agreement. That's the first thing I believe, that the logic of encryption is taking us there. The second thing I believe is, as both you and Mr. Conyers said, there's a lot of good about this, a lot of benefits to this. All of us will be able to keep private and keep protected from thieves of all kinds the things that matter most to us. Our ideas, our innovation, our secret thoughts, our hopes, our dreams. There is a lot to love about this. We will all be able to have storage spaces in our life that nobody else can get into. The third thing I believe is that there are many costs to this. For the last 2 centuries, public safety in this country has depended in large measure on the ability of law enforcement agents going to courts and obtaining warrants to look in storage areas or apartments or to listen with appropriate predication and oversight to conversations. That is the way in which law enforcement brings us public safety. It is very, very important, and it's been part of the balance in ordered liberty, right? That sometimes the people's stuff can be looked at, but only with predication and only with oversight and approval by an independent judiciary. The fourth thing I believe is that these 2 things are in tension in many contexts, increasingly in our national security work and in law enforcement work generally across the country. We see it obviously in ISIL's efforts to reach into this country and using mobile messaging apps that are end-to-end encrypted, task people to kill innocent people in the United States. That is a huge feature of our national security work and a major impediment to our counterterrorism work, because even with a court order, what we get is unreadable. To use a technical term, it's gobbledygook, right? We cannot decrypt that which is covered by strong encryption. We also see it in criminal work across the country. See very tragically last year in Baton Rouge, where a pregnant woman, 8 months pregnant, was killed by somebody she opened the door to, and her mom says she kept a diary, but it's on her phone, which is locked. And so the case remains unsolved. And most recently and most prominently, as both Mr. Conyers and Chairman mentioned, we see it in San Bernardino, a case where 2 terrorists in the name of ISIL killed 14 people and wounded 22 others at an office gathering, and left behind 3 phones, 2 of which, the cheaper models, they smashed beyond use, and the third was left locked. In any investigation as done competently, the FBI would try to get access to that phone. It's important that it's a live, ongoing terrorism investigation, but in any criminal investigation, a competent investigator would try and use all lawful tools to get access to that device. And that's what you see happening in San Bernardino. The San Bernardino case is about that case. It obviously highlights the broader issue, and of course it'll be looked upon by other judges and other litigants, but it is about the case and trying to do a competent job of understanding, is there somebody else, and are there clues to what else might have gone on here? That is our job. The fifth thing I believe is that democracies resolve these kind of really hard questions through robust debate. I think the FBI's job is very, very limited. We have 2 jobs. The first is to investigate cases like San Bernardino and to use tools that are lawful and appropriate. The second thing, it's our job to tell the American people the tools you are counting on us to use to keep you safe are becoming less and less effective. It is not our job to tell the American people how to resolve that problem. The FBI is not some alien force imposed upon America from Mars. We are owned by the American people. We only use the tools that are given to us under the law. And so our job is simply to tell people there is a problem. Everybody should care about it. Everybody should want to understand if there are warrant-proof spaces in American life, what does that mean? And what are the costs of that, and how do we think about that? I don't know what the answer is. It may be the American people, through Congress and the courts, decide it's too hard to solve, or law enforcement can do its job well enough with strong encryption, covering our communications and our papers and effects, or that it's something that we have to find a way to fix to achieve a better balance. I don't know. My job is to try to offer thoughtful explanations about the tools the FBI has and to bring them to the attention of the American people and then answer questions about that. So I'm very, very grateful for this forum, very, very grateful for this conversation. There are no demons in this debate. The companies are not evil, the government's not evil. You have a whole lot of good people who see the world through different lenses, who care about things, all care about the same things in my view. The companies care about public safety. The FBI cares about innovation and privacy. We devote our lives to trying to stop people from stealing our innovation, our secrets, and hacking into our devices. We care about the same things, which should make this, in a way, an easier conversation, which I very much look forward to. Thank you.
Thank you, Director Comey. We'll now proceed under the 5-minute rule with questions for the witness, and I'll begin by recognizing myself. Director, there has been quite a bit of debate about the government's reliance on the All Writs Act, which most people had never heard of until the last week or so. That is being used in this case to try to compel Apple to bypass the auto erase functions on the phone. It has been characterized as an antiquated statute dating back to 1789 that was never intended to empower the courts to require a third party to develop new technology. How do you respond to that characterization? Has the FBI relied on the Act in the past to gain access to iPhones or other similar devices? And is the Act limited to the circumstances in which Congress has already imposed a statutory duty on a third party to provide assistance?
Yeah, thank you, Mr. Chairman. I smile a little bit when I hear that because old doesn't mean bad. At least I hope it doesn't, because I'm rapidly approaching that point. The Constitution is as old or older than the All Writs Act, and I think that's still a pretty useful document. It's a tool that I used. I think there's some members of the committee are former federal prosecutors. Every assistant U.S. attorney knows it. I used it when I started as an AUSA in 1987. It is an act that Congress passed when the Constitution was a baby, so there was a vehicle for judges to get their orders complied with. And it's been used many, many, many times and interpreted by the courts many times, including by the Supreme Court. The cases at hand are simply about, as I understand it, what is the reach of the All Writs Act? It's still good law, but how far does it extend, especially given how technology has changed? And I think the courts are going to sort that out. There was a decision yesterday in New York. There'll be decisions in California. There'll probably be lots of others because this is a problem law enforcement is seeing all over the country.
Let me ask you about that decision in New York, because in its brief in the California case, Apple argues that a provision of CALEA, another federal statute, actually prohibits the magistrate from ordering it to design a means to override the auto erase functions on the phone. Just yesterday, a magistrate in New York upheld that argument. Can you comment on that?
Not in an intelligent way, because I haven't read the decision out of New York. I understand the basic contours of the argument. I don't fully get it, honestly, because CALEA is about data in motion, and this is about data at rest. But I also think this is the kind of thing judges do. They take acts of Congress and try to understand, so what does it mean, especially given changing circumstances? So I expect it'll be bumpy. There'll be lots of lawyers paid for hours of work, but we will get to a place where we have the courts with an understanding of its reach.
Now, if the FBI is successful in requiring Apple to unlock this phone, that won't really be a one-time request, correct?
Well, the issue of locked phones, certainly not, because it's become
It will set a precedent for other requests from the Federal Bureau of Investigation and any other law enforcement agency to seek the same assistance in many, many, many other cases.
Sure, potentially, because any decision of a court about a matter is potentially useful to other courts, which is what a precedent is. I happen to think, having talked to experts, there are technical limitations to how useful this particular San Bernardino technique will be, given how the phones have changed. But sure, other courts, other prosecutors, other lawyers for companies will look to that for guidance or to try and distinguish it.
So that technology, once developed, which I presume they could destroy again, but then we'll have to recreate hundreds of times, how confident are you, whichever procedure Apple decided to pursue, how confident are you that what you are requesting, which is the creation effectively of a key, a code, how confident are you that will remain secure and allow all the other customers of Apple, and when this is applied to other companies' technology as well, how confident are you that it will not fall into the wrong hands and make everyone's communication devices less secure, not more secure?
First, I got to quibble a little bit with the premise of your question. I hear folks talk about keys and backdoors. I actually don't see that this way. I mean, there are issues about backdoors. This is about, there's already a door on that iPhone. Essentially, we're asking Apple, take the vicious guard dog away, let us try and pick the lock. The later phones, as I understand the 6 and after, there aren't doors. So there isn't going to be, can you take the guard dog away and let us pick the lock? But look, I have a lot of faith, maybe I don't know them well enough, in the company's ability to secure their information. The iCloud, for example, is not encrypted, right? But I don't lie awake at night worrying about whether they're able to protect the contents of the iCloud. They are very, very good at protecting their information and their innovation. So no thing is for certain, but I think these folks are pros.
Thank you very much. Chair recognizes the ranking member, Mr. Conyers, for his questions.
Thank you, Chairman Goodlatte. and welcome again to our forum. You're a very regular visitor to the Judiciary Committee. Director Comey, it's been suggested that Apple has no interest in helping law enforcement in any criminal case, and that the company cares more about marketing than about investigating a terrorist attack. In your view, are companies like Apple generally cooperative the FBI when the FBI asks for assistance, accompanied by appropriate legal process? Did Apple assist with this particular investigation?
I think in general, all American companies, and I can't think of an exception sitting here, want to be helpful, especially when it comes to public safety, because they have families and children just as we do. So that's the attitude we're met with. And in this particular case, as in many others, Apple was helpful to us. We had lots of good conversations about what we might be able to do to get this device open. And we got to a place where they said, for reasons that I don't question their motive, we're not willing to go further. And the government made a decision. We still have an avenue to pursue with the judge. We'll go to the judge. But I don't question their motives.
All right. Thank you. I sense that you are still reluctant to speak about how your success in this case might set a precedent for future actions. You indicated last week that this litigation may guide how other courts handle similar requests. Could you elaborate on that, please?
Sure. First of all, let me say this. I've been trying to explain to people this case in San Bernardino is about this case. And the reason I've tried to say that so much publicly is I worry very much about the pain, frankly, to the victims in this case when they see this matter that's so important to them becoming a vehicle for a broader conversation. So I want to make sure that everybody, especially the FBI, remains grounded in the fact this is about that case. My wife has a great expression she uses to help me be a better person, which is, it's not about you, dear. This case in San Bernardino is not about the FBI, it's not about Apple, it's not about Congress, it's not about anything other than trying to do a competent investigation in an ongoing active case. That said, of course, any decision by a judge in any forum is going to be potentially precedential in some other form, not binding, but guidance, either positive or against. The government lost a case yesterday in Brooklyn. We could lose the case in San Bernardino and it would be used as precedent against the government. That's just the way the law works, which I happen to think is a good thing.
Thank you. If you succeed in this case, will the FBI return to the courts in future cases to demand that Apple and other private companies assist you in unlocking secure devices?
Potentially, yes. If the All Writs Act is available to us and the relief under the All Writs Act, as explained by the courts, fits the powers of the statute, of course.
And finally, I think we can acknowledge then that this case will set some precedent. And if you succeed, you will have won the authority to access encrypted devices, at least for now. Given that you've asked us to provide you with that authority since taking your position at the Bureau, and given that Congress has explicitly denied you that authority so far, can you appreciate our frustration that this case appears to be little more than an end run around this committee?
I really can't, Mr. Conyers. First of all, I don't recall a time when I've asked for a particular legislative fix. In fact, the administration's position has been they're not seeking legislation at this time. But we're investigating a horrific terrorist attack in San Bernardino. There's a phone that's unlocked that belonged to one of the killers. The All Writs Act was used since I was a boy. We think there's a reasonable argument to have the court use the All Writs Act to direct the company to open that phone. That's what this is about. If I didn't do that, I ought to be fired, honestly. I can also understand your frustration at the broader conversation because it goes way beyond this case. This case will be resolved by the courts. It does not solve the problem we're all here wrestling with.
I thank the director, and I yield back any unused time. Thank you, Mr. Chairman.
Thank you. And the chair recognizes the gentleman from Ohio, Mr. Shabbat, for 5 minutes.
Thank you, Mr. Chairman. I have a statement from the Application Developers Alliance here that I'd like to have included in the record.
Without objection, it will be made a part of the record.
Thank you, Mr. Chairman. And Director Comey, like yourself, I happen to be a graduate of the College of William and Mary, so I'm going to start off with a tough question. Anything nice you'd like to say about the College of William and Mary?
I could tell there was a glow coming from your seat. That's explained by your being a member of the tribe. Best thing ever happened to me besides, I actually met my wife there. That's the best thing ever happened to me. Second best is that I was there.
Excellent. Yeah, it's a great place to go. There's two members currently. Ms. Titus of Nevada is also a graduate. Now, this hearing is about electronic data security, or as you
Chair
described.
is happy to extend additional time to the gentleman for recognizing an important Virginia educational institution.
I appreciate the chairman. And as is already indicated, this is about electronic data security, or as you described it, keeping our stuff online private. So I'd like to ask you this, and it may seem a little off topic, but I don't think it is. A few weeks back, the FBI's General Counsel, James Baker, acknowledged that the FBI is, quote, working on matters related to former Secretary of State Hillary Clinton's use of a private email server, unquote. And then the White House Press Secretary, Josh Earnest, stated that, quote, some officials over there, referring to the FBI, had said that Hillary Clinton is not a target of this investigation and that it's not trending in that direction, unquote. And the president then weighed in, even though he apparently had never been briefed on the matter, commenting that he didn't see any national security implications in Hillary's emails, and obviously this is a matter of considerable import. Is there anything that you can tell us as to when this matter might be wrapped up one way or the other?
I can't. Congressman, as you know, we don't talk about our investigations. What I can assure you is that I am very close personally to that investigation to ensure that we have the resources we need, including people and technology, and that it's done the way the FBI tries to do all of its work, independently, competently, and promptly. That's our goal, and I'm confident it's being done that way, but I can't give you any more details beyond that.
I certainly understand, and I appreciate it. I thought you might say that, but you can't blame me for trying. Let me move on. If Apple chose to comply with the government's demand, maybe it does have the technical expertise and time and finances to create such a vulnerability so we can get in and get that information. But let me ask you, what about a small business? I happen to be the chairman of the House Small Business Committee. Wouldn't such a mandate to, say, a small company, a startup, say with 4, 5, 6 employees, wouldn't that be a huge burden on a small business to have to comply with this sort of thing?
I think it might be, and that's one of the factors, as I understand it, courts consider in passing on an all Writs Act request, the burden to the private actor. How much would it cost them? How much time and effort? And I think Apple's argument in this case is it would take us a ton of effort, time, and money to do it, and so that's one of the reasons we shouldn't be compelled to do it. So it's a consideration built into the judicial interpretations of the Act.
Thank you. As chair of the committee, we'd ask you certainly to consider how this could affect 7 out of 10 new jobs created in the economy are small business folks. Half of the people employed in this country in the private sector are small businesses, and I think we should always consider them. Let me move on to something else. In his testimony from our December 2015 hearing about H.R. 699, the Email Privacy Act, Richard Littlehale, the Assistant Special Agent in charge of Criminal Investigation Division of the Tennessee Bureau of Investigations, voiced a frustration with the increasing technological capabilities of both criminals and non-criminals. Rather than trying to arguably infringe on the Fourth Amendment rights of all Americans, would it be possible to better train our law enforcement officers and equip them to keep up with this changing world that we're discussing today?
Well, there's no doubt that we have to continue to invest in training so that all of our folks are digitally literate and able to investigate in that way. The problem we face here is all of our lives are on these devices, which is why it's so important that they be private. That also means all of criminals and pedophiles and terrorists' lives are on these devices. And if they're warrant proof, even a judge can't order access to a device, that is a big problem. I don't care how good the cop is, I don't care how good the agent is, that is a big problem. So that we can't quite train our way around.
Thank you very much. I'm almost out of time, so let me conclude with Go Tribe. Thank you.
Chair thanks the gentleman. Recognize the gentleman from New York, Mr. Nadler.
Thank you. Since we've gone a little far afield here, let me do so again very briefly to point out that, among others, Thomas Jefferson, who among his minor accomplishments was the founder of the Democratic Party, was also a graduate of William and Mary. Mr. Comey, Director Comey, the attack, well, we're all certainly very condemning of the terrorist attack in San Bernardino, and we all, our hearts go out to the families of the victims, and I commend the FBI for everything you have done to investigate this matter. Now, the 2 terrorists are dead, and another co-conspirator, the neighbor, is in jail. You've used the USA Freedom Act to track their phone calls and investigate, which this committee wrote last year, to track their phone calls and investigate everyone they ever spoke to on that phone. So the FBI has done a great job already. Now, let me ask a few questions. It's my understanding that we have found that the attack in San Bernardino was not in any way planned or coordinated by ISIS. Is that correct? It may have been inspired by, but not directed or planned by.
Right, so far as we know, correct.
And have you eliminated any connection between the 2 suspects and any overseas terrorist organization?
Eliminated any? We have not.
Have you seen any evidence of any? It's a better way of putting it.
We have not seen any evidence of that.
Okay. Now, given those facts, so there's no evidence of any coordination with anybody else. It's the 2 homegrown, self-motivated, perhaps inspired by ISIS terrorists. Now, the investigators seized the iPhone in question on December 3rd. The FBI reached out to Apple for assistance on December 5th. Apple started providing the FBI with information, with account information I gathered the same day. But then the next day, on December 6th, at the instruction of the FBI, San Bernardino County changed the password to the iCloud account associated with that device. They did so without consulting Apple, at the instruction or suggestion of the FBI, and changing that password foreclosed the possibility of an automatic backup that would have allowed Apple to provide you with this information without bypassing its own security, and thus necessitated in the first place the application to the court that you made and that we're discussing today. In other words, if the FBI hadn't instructed San Bernardino County to change the password to the iCloud account, all of this would have been unnecessary, and you would have had that information. So my question is, why did the FBI do that?
I have to, first of all, I want to choose my words very, very carefully. I said there is no evidence of direction from overseas terrorist organizations. This is a live investigation. I can't say much more beyond that. This investigation is not over. And I worried that embedded in your question was that you understood me to be saying that. Second, I do think, as I understand from the experts, there was a mistake made in that 24 hours after the attack, where the county, at the FBI's request, took steps that made it impossible later to cause the phone to back up again to the iCloud. The experts have told me I'd still be sitting here. I was going to say unfortunately, not unfortunately, fortunately. I'm glad I'm here. But we would still be in litigation because the experts tell me there's no way we would have gotten everything off the phone from a backup. I have to take them at their word, but that part of your premise of your question is accurate.
Okay. So the second part of my question, excuse me, the second part of my question is, it wasn't until almost 50 days later, on January 22nd, when you served the warrant, given the allegedly critical nature of this information, why did it take the FBI 50 days to go to court?
I think there were a whole lot of conversations going on in that interim with companies, with other parts of the government, with other resources to figure out if there was a way to do it, short of having to go to court.
Okay, thank you. Now, getting off this specific case, because I do think we all understand that it's not just a specific case, it will have widespread implications in law. And however the courts resolve this, which is essentially a statutory interpretation case, the buck is going to stop here at some point. We're going to be asked to change the law. So encryption software is free, open source, and widely available. If Congress were to pass a law forcing U.S. companies to provide law enforcement with access to encrypted systems, would that law stop bad actors from using their own encryption?
It would not.
It would not. So the bad actors would just get around it.
Sure. Encryption's always been available to bad actors, nation states.
So if we were to pass a law saying that Apple and whoever else had to put back doors or whatever you want to call them into their systems, the bad actors that were and with all the appropriate, with all the not appropriate, all the concomitant surrenders of privacy, et cetera, the bad actors could easily get around that by making their own encryption systems.
The reason I'm hesitating is I think we're mixing together two things, data in motion and data at rest. The bad guys couldn't make their own phones, but the bad guys could always try and find a device that was strongly encrypted. The big change here happened in the fall of 2014 when the companies flipped from available encryption to default. And that's the shadow of going dark.
But couldn't foreign companies and bad actors generally do that, whatever we said?
Sure, potentially people could say, I love this American device, but because I worry about a judge ordering access to it, I'm going to buy this phone from a Nordic country that's different in some way. That could happen. I have a hard time seeing it happen a lot, but it could happen.
Thank you. My time has expired. Thank you.
Chairman, I'd like to ask for unanimous consent some documents be placed in the record at this time. I'd like to ask unanimous consent that patent number 0240732, patent
Without objection.
Thank you. Additionally, 27353, another patent. Additionally, a copy of the USA Today that entitled Ex-NSA Chief Backs Apple on iPhone. Additionally, from Science and Technology, an article that says Department of Homeland Security awards $2.2 million to Malibu, California company for mobile security research, and in other words, an encryption-proof, unbreakable phone. Additionally, and lastly, the article in Politico today on the New York judge's ruling in favor of Apple.
Without objection, they will all be made a part of the record.
Thank you, Mr. Chairman.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. Justice Scalia said, it's best, said best what I'm going to quote almost 30 years ago in Arizona v. Hicks, in which he said, there is nothing new in the realization that the Constitution sometimes insulates the criminality of a few in order to protect the privacy of all of us. I think that stands as a viewpoint that I have to balance when asking you questions. As I understand the case, and there's a lot of very brilliant lawyers and experienced people that know about all writs act, but what I understand is that you, in the case of Apple in California, are demanding through a court order that Apple invent something. Fair to say that they have to create something. And if that's true, then my first question to you is, the FBI is the premier law enforcement organization with laboratories that are second to none in the world. Are you testifying today that you and or contractors that you employ could not achieve this without demanding an unwilling partner do it?
Correct.
And you do so because you have researched this extensively?
Yes, we've worked very, very hard on this. We're never going to give up, but we've worked.
Did you receive the source code from Apple? Did you demand the source code?
Did we ask Apple for their source code? Not that I'm aware of.
Okay, so you couldn't actually hand a software person the source code and say, can you modify this to do what we want, if you didn't have the source code. So who did you go to, if you can tell us, that you consider an expert on writing source code changes that you want Apple to do for you? You want them to invent it, but who did you go to?
Not sure I'm following the question.
Well, you know, I'm going to assume that the burden of Apple is X. But before you get to the burden of Apple doing something it doesn't want to do, because it's not in its economic best interest, and they've said that they have real ethical beliefs that you're asking them to do something wrong, sort of their moral fiber, but you are asking them to do something, and there's a burden. No question at all. There's a burden. They have to invent it. And I'm asking you, have you fully viewed the burden to the government? We spend $4.2 trillion every year. You have a multi-billion-dollar budget. Is the burden so high on you that you could not defeat this product either through getting the source code and changing it or some other means? Are you testifying that?
I see. We wouldn't be litigating if we could. We have engaged all parts of the U.S. government to see, does anybody have a way, short of asking Apple to do it, with a 5C running iOS 9 to do this, and we do not.
Okay, well, let's go through the 5C running iOS 9. does the 5C have a non-volatile memory in which all of the encrypted data and the selection switches for the phone settings are all located in that encrypted data?
I don't know.
Well, it does.
Okay.
And take my word for it for now. So that means that you can, in fact, remove from the phone all of its memory, all of its non-volatile memory, its disk drive, if you will, and set it over here and have a true copy of it that you could conduct infinite number of attacks on. Let's assume that you can make an infinite number of copies once you make one copy, right?
I have no idea.
Well, let's go through what you asked. And I'm doing this because I came out of the security business, and this befuddles me that you haven't looked at the source code and you don't really understand the disk drive, at least to answer my rather, dumb questions, if you will. If there's only a memory, and that memory, that non-volatile memory sits here, and there's a chip, and the chip does have an encryption code that was burned into it, and you can make 10,000 copies of this chip, this non-volatile memory hard drive, then you can perform as many attacks as you want on it. Now, you've asked specifically Apple to defeat the finger code so you can attack it automatically, so you don't have to punch in codes. You've asked them to eliminate the 10 and destroy. But you haven't, as far as I know, asked them, okay, if we make 1,000 copies or 2,000 copies of this, and we put it with the chip, and we run 5 tries, 00 through 04, and then throw that image away and put another one in, and do that 2,000 times, won't we have tried with a non-changing chip and an encryption code that is duplicated 2,000 times, won't we have tried all 10,000 possible combinations in a matter of hours? If you haven't asked that question, the question is, how can you come before this committee and before a federal judge and demand that somebody else invent something if you can't answer the questions that your people have tried this?
First, I'm the director of the FBI. If I could answer that question, there'd be something dysfunctional in my leadership.
Now, I only asked if your people had done these things. I didn't ask you if that would work. I don't know if that would work. I asked you, who did you go to? Did you get the source code? Have you asked these questions? Because you're expecting somebody to obey an order to do something they don't want to do, and you haven't even figured out whether you could do it yourself. You've just told us, well, we can't do it, but you didn't ask for the source code, and you didn't ask the questions I asked here today, and I'm just a guy that did electronics by absence.
The time of the gentleman has expired, and the director is permitted to answer the question.
Thank you, Mr. Chairman.
Do so.
I did not ask the questions you're asking me here today, and I'm not sure I fully even understand the questions. I have reasonable confidence, in fact, I have high confidence, that all elements of the U.S. government have focused on this problem and have had great conversations with Apple. Apple has never suggested to us that there's another way to do it other than what they've been asked to do in the All Writs Act. It could be when the Apple representative testifies, you'll ask him and we'll have some great breakthrough, but I don't think so. But I'm totally open to suggestions. Lots of people have emailed ideas. I've heard about mirroring, and maybe this is what you're talking about. We haven't figured it out, but I'm hoping my folks are watching this, and if you've said something that makes good sense to them, we'll jump on it. We'll let you know.
Thank you.
The chair recognizes the gentlewoman from California, Lofgren, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Director Comey, for your service to our country and your efforts to keep us safe. It is appreciated by every member of this committee, and along with your entire agency. We do value your service and appreciate it. I remember in law school the phrase, bad cases make bad law. I'm sure we all heard that. And I think this might be a prime example of that rule. We can't think of anything worse than what happened in San Bernardino. 2 terrorists murdering innocent people. It's outrageous. It sickens us, and it sickens the country. But the question really has to be, what is the rule of law here? Where are we going with this? And as I was hearing your opening statement talking about a world where everything is private, it may be that the alternative is a world where nothing is private. Because once you have holes in encryption, the rule is, it's not a question of if, but when those holes will be exploited and everything that you thought was protected will be revealed. Now, the United States law often tends to set international norms, especially when it comes technology policy. And in fact, China removed provisions that required backdoors from its counterterrorism law passed in December because of the strong international norm against creating cyber weaknesses. But last night I heard a report that the ambassadors from America, the United States, Canada, Germany, and Japan sent a joint letter to China because they're now thinking about putting a hole in encryption in their new policy. Did you think about the implication for foreign policy, what China might do when you filed the motion in San Bernardino, or was that not part of the equation?
Yeah, I don't remember thinking about it in the context of this particular investigation, but I think about it a whole lot broadly, which is one of the things that makes it so hard. There are undoubtedly international implications. Actually, I think less to the device encryption question and more to the data in motion question. But yeah, I have no doubt that there's international implications. I don't have good visibility into what the Chinese require from people who sell devices in their country. I know it's an important topic.
Before I forget, Mr. Chairman, I'd like to ask unanimous consent to put in the record an op-ed that was printed in the Los Angeles Times today, authored by myself and my colleague, Mr. Issa, on this subject.
How could anyone object to that being part of the record?
I just note that in terms of the, you mentioned that the code at Apple, that they've done a pretty good job of protecting their code, and you didn't remember anything getting out loose. But I do think, you know, if you take a look, for example, at the situation with Juniper Networks, where they had, their job is cybersecurity, really, and they felt that they had strong encryption, and yet there was a vulnerability, and they were hacked. And it put everybody's data, including the data of the U.S., I mean, of the FBI and the State Department and the Department of Justice at risk, and we still don't know what was taken by our enemies. Did you think about the Juniper Networks issue when you filed the All Writs Ask report, remedy in San Bernardino?
No, but I think about that and a lot of similar intrusions and hacks all day long, because it's the FBI's job to investigate those and stop those.
I was struck by your comment that Apple hadn't been hacked, but in fact, the iCloud accounts have been hacked in the past. I think we all remember in 2014 the female celebrity accounts that were hacked from the cloud, from iCloud, and CNBC had a report that China likely attacked iCloud accounts. And then in 2015, last year, Apple had to release a patch in response to concerns that there had been brute force attacks at iCloud accounts. So I'm anticipating, we'll see, that Apple will take further steps to encrypt and protect not only its operating system that it has today, but also the protection as well as the iCloud accounts. And I'll just close with this. I have on my iPhone all kinds of messaging apps that are fully encrypted, some better than others. Some were designed in the United States. A bunch of them were designed in other countries. And I wouldn't do anything wrong on my iPhone, but if I were a terrorist, I could use any one of those apps and communicate securely, and there wouldn't be anything that the U.S. government, not the FBI, not the Congress or the President, could do to prevent that from occurring. So I see this as, the question of whether my security is going to be protected, but the terrorists will continue abate. And I thank you, Mr. Comey, for being here. I yield back, Mr. Chairman.
Chair thanks, gentlewoman. And the chair recognizes the gentleman from Texas, Mr. Poe, for 5 minutes.
Thank you, Director. Appreciate you being here. Start with some basics. The Fourth Amendment protects citizens from government. Citizens have rights. Government has power. There is nowhere I see in the Fourth Amendment that there is a, except for terrorist cases exception, or fear cases that the Fourth Amendment should be waived. I signed lots of warrants in 22 years from everybody, including the FBI. Four corners of the warrant, what is to be searched, and law enforcement typically would fulfill the duty or ability in that warrant as far as they could, which is a good thing, and return the warrant. Now we have a situation where the issue is not lawful possession. FBI is in lawful possession of the San Bernardino phone, lawful possession of the phone in New York. You agree with me on that?
Yes.
So we're not talking about whether the phones are in lawful possession. The issue is whether, the specific issue is whether government can force Apple, in this case, to give them the golden key to unlock the safe because they can't develop the key. I know that's kind of simplistic, but is that a fair statement or not?
No.
It's not?
I think
well, let me ask you this. Okay, you say it's not. Apple develops the software and gives it to, and unlocks the phone, but this is not the only phone in question. Is that correct? There are other phones that the FBI has in lawful possession that you can't get into.
Sure. Law enforcement increasingly encounters phones, investigations all over the place that can't be unlocked.
Okay, so
I mentioned the Baton Rouge case, too.
All right, there's several. How many of those cases do you have in lawful possession that you want to get into the phone, but you can't get into it because you don't have the software to break into it or to get into it?
Yeah, I don't know the number. A lot.
A lot.
And they're all different, which is what makes it hard to talk about any one case without being specific about what.
But you're in lawful possession of all these phones. This is not the issue of whether FBI lawfully possesses them. You have these phones. You can't get into them. Here's a specific phone. You want iPhone, Apple to develop software to get into this phone. My question is, what would prevent the FBI from then taking that software and going into all those other phones you have and future phones you seize?
I see. This seems like a small difference, but I think it's actually kind of a big difference. The direction from the judge is not to have Apple get us into the phone. It's have Apple turn off, by developing software that will tell the phone to turn it off, the auto erase and the delay features, so that we can try and guess the password. And so in theory, if you had another 5C running iOS 9, which is what makes this relief possible, I mean it when I say it's obsolete, because I understand the 6s. There is no door for us even to try and pick the lock on, so it wouldn't work. But if there were phones in the same circumstances, sure, you could ask for the same relief from a court to try and make effective the search warrant.
So rather than giving you the key, it's really you want Apple to turn the security system off so they can get into the phone or you can get into the phone.
Yeah, my homely metaphor was take away the drooling watchdog is going to attack us if we try and open it. Give us time to pick the lock.
Or like the Viper system that Mr. Issa developed. Turn off the Viper system so you can get into the phone. And it boils down to the fact of whether or not government has the ability to demand that occur. We have two court rulings. They're different. I've read the opinions. They're different, little different cases. Would you agree or not? Congress has to resolve this problem. We shouldn't leave it up to the judiciary to make this decision. Congress should resolve the problem and determine exactly what the expectation of privacy is in these particular situations of encryption or no encryption, key, no key. Would you agree or not?
I think that the courts are competent, and this is what we've done for 230 years, to resolve the narrow question about the scope of the All Writs Act, but the broader question we're talking about here goes far beyond phones or far beyond any case. This collision between public safety and privacy, the courts cannot resolve that.
So, and only the Congress should then resolve what is the expectation of privacy in this high-tech atmosphere of all this information stored in many different places, on the cloud, on the phone, wherever it's stored, and would you agree or not? I'm just asking, should Congress resolve this issue of expectation of privacy of the American citizens?
I think Congress certainly has a critical role to play. Like I said, since the founding of this country, the courts have interpreted the Fourth Amendment and the Fifth Amendment, so they are competent. That's an independent branch of government, but I think there's a huge role for Congress to play. And we're playing it today, I hope.
I agree with you. I think it's Congress's responsibility to determine the expectation of privacy in this high-tech world. And I yield back, Mr. Chairman.
Time of the gentleman has expired. The gentleman from Tennessee is recognized for 5 minutes. There is 9 minutes and 45 seconds remaining in this vote. I'll take a chance if the gentleman from Tennessee will.
If you want to go, I'll go, or I'll come back.
Well, I'm trying to move it along as
Thank you.
not keep the director any longer than we have to. So go ahead.
Director Comey, are there limitations that you could see in permitting the FBI or government and a court to look into certain records, certain type of cases, certain type of circumstances that you could foresee, or do you want it open for any case where there could be evidentiary value?
Not sure I'm following you. I like the way we have to do our work, which is go to a judge in each specific case and show lawful authority and a factual basis for access to anybody's stuff.
But if we decided to pass a statute and we thought it should be limited in some way, maybe to terrorism, or maybe to something where there's a reasonable expectation that a person's life is in jeopardy, or that you could apprehend somebody who has taken somebody's life, have you thought about any limits? Because, you know, under what you're saying, you go to a court. I mean, you could go to a court for cases that are not capital cases, and that's, I don't think anybody here is thinking. What the public's fascinated, or not say riveted on, is the fact that what happened to San Bernardino was so awful, and if we can find some communication or some list of that was in the cloud that these people contacted, you know, Osama bin Laden's cousin, and that they get and find out that he had something to do with it, then that's important. But if you're talking about getting into somebody's information to find out who they sold, you know, 2 kilos or 2 bags or whatever, it's a whole different issue. Where would you limit it if you were coming up with a statute that could satisfy both your interest in the most extreme important cases and yet satisfy privacy concerns?
Yeah, I see. I'm sorry. I misunderstood the question. I don't know and haven't thought about it well enough, and frankly, I don't think that ought to be the FBI making that, offering that, those parameters to you. There is precedent for that kind of thing. We can only seek wiretaps, for example, on certain enumerated offenses in the United States. So it has to be really serious stuff before a judge can even be asked to allow us to listen to someone's communications in the United States. It can't just be any offense. So there's precedent for that kind of thing, but I haven't thought about it well enough.
Thank you. Because I'm slow in getting up there to vote, and the Republicans hit the real quickly, I'm going to yield back the balance of my time and start to walk fast.
Chair, thanks, gentlemen. The committee will stand in recess. We have 2 votes on the floor with 7 minutes remaining in the first vote. Mr. Director, we appreciate your...
Mr. Director? Mr.
Pam, I'm ready. This hearing on encryption with the FBI Director Comey and also later the General Counsel of Apple will continue. They're on a break here for a series of votes on the House floor, a couple of votes on the House floor. and you can follow those over on C-SPAN. We expect them back in about a half an hour or so, and while they're in this recess, we'll continue our live coverage when they return, but while they're in this recess, we'll show you some of the opening statements from just a short while ago.
Continue with questions for Director Comey, and the chair recognizes the gentleman from Utah, Mr. Chaffetz, for 5 minutes.
Thank you, Mr. Chairman, and to the Director, thank you so much for being here. As I've mentioned before, my grandfather was a career FBI agent, so I have great affinity for the agency and what you do and how you do it. They almost always make us proud. But the big question for our country is, you know, how much privacy are we going to give up in the name of security? And as you said, there's no easy answer to that. But when historically, with all the resources and assets of the federal government, all the expertise, all the billions of dollars, when has it been the function of government to compel or force a private citizen or a company to act as an agent of the government to do what the government couldn't do?
I suppose that's a legal question. In lots of different circumstances, private entities have been compelled by court order to assist, again, through the All Writs Act. New York Telephone is the Supreme Court case, the seminal case on the topic.
So let's talk for a moment about what you can see and what you can do. With all due respect to the FBI, they didn't do what Apple had suggested they do in order to retrieve the data, correct? I mean, when they went to change the password, that kind of screwed things up, did it not?
Yeah, I don't know that that's accurate, actually. I wasn't there, don't have complete visibility, but I agreed with the questioner earlier. There was an issue created by the effort by the county at the FBI's request to try and reset it to get into it quickly.
And if they didn't reset it, then they could have gone to a Wi-Fi, local Wi-Fi, a known Wi-Fi access, and performed that backup so they could go to the cloud and look at that data, correct?
Right, you could get in the cloud through that mechanism, anything that was back-upable, to make up a word, to the cloud, but that does not solve your full problem. I think I'd still be sitting here talking about it otherwise.
Well, but let's talk about what the government can see on using a phone, and it's not just an iPhone, but you can look at metadata, correct?
Yes.
The metadata is not encrypted, correct? If I called someone else, or that phone had called other people, all of that information is available to the FBI, correct?
In most circumstances, right, metadata.
In this case, let's talk about this case. You want to talk about this case. You can see the metadata, correct?
My understanding is we can see most of the metadata.
How would you define metadata?
I was just going to say that. Metadata, as I understand it, is records of time of contact, numbers assigned to the particular caller or texter. It's everything except content. You can't see what somebody said, but you can see that I texted to you in theory. My understanding is with text in particular, that's tricky, particularly texting using iMessage. There's limitations on our ability to see the metadata around that. Again, I'm not an expert, but that's my understanding.
And do you believe that geolocation, if you're tracking somebody's actual where they are, is that content or is that metadata?
My understanding is it depends upon whether you're talking historical or real time when it comes to geolocation data, but it can very much implicate the warrant requirement and does in the FBI's work a lot.
So that's what we're trying to, what's frustrating to me, being on Judiciary, being the chairman of the Oversight Committee, there is nobody on this panel as in a republic, a representative of the people, that have been able to see what the guidance is post-Jones and understanding how you interpret and what you're actually doing or not doing with somebody's geolocation.
You've asked that of the FBI and not been able to get it?
The Department of Justice to date have been asking for this for years. What's frustrating is the Department of Justice is asking for more tools, more compulsion, and we can't even see what you're already doing. We can't even see to the degree you're using stingrays and how they work. I mean, I think I understand how they work, but what sort of requirements are there? Is it articulable suspicion? Is there a probable cause warrant that's being used or needed? And it's not just the FBI. I mean, you've got the IRS and Social Security and others using stingrays. Again, other tools that I would argue are actually content to somebody's life and not just the metadata that you are able to see. So how do we get exposure? How do we How do we help you if you routinely refuse, and I say you, meaning the Department of Justice, access in explaining to us what tools you already do have and what you can access? How do we solve that?
Yeah, I don't have a great answer sitting here. I'll go find out what's been asked for and what's been given. I like the idea of giving as much transparency as possible, because I think people find it reassuring, at least with respect to the FBI, to take cell phone tower simulators. We always use search warrants. And so that shouldn't be that hard to get you that information.
What I worry about, you may be responsible, and I don't know what the IRS is doing with them, and I have a hard time figuring out when that is responsible. Last comment, Mr. Chairman. To what degree are you able to access and get into, either in this case or broadly, are you able to search social media in general, and are you using that as an effective tool to investigate and combat what you need to do?
Time of the gentleman has expired. The witness can answer the questions.
Social media is a feature of all of our lives, and so it's a feature of a lot of our investigations. Sometimes it gives us useful information, sometimes not. It's hard to answer in the abstract, but it's a big part of our work.
Chair thanks, gentlemen, and recognize the gentleman from Georgia, Mr. Johnson, for 5 minutes.
Thank you, Director Comey. The framers of our Constitution recognized a right to privacy that Americans would enjoy. Fourth Amendment pretty much implies that right to privacy, does it not?
I'm not a constitutional scholar. I think a scholar, if he were sitting here, might say it's not the Fourth Amendment that's the source of the right to privacy. It's other amendments of the Constitution. But that's a technical answer. The Fourth Amendment is critically important because it's a restriction on government power. You may not look at the people's stuff, their houses, their effects, without a warrant and without independent judiciary.
But it also grants impliedly to the government, the Fourth Amendment, the authority to search and seize when the search or seizure is reasonable. Is that correct?
Again, to be technical, I think the answer is Congress has given the government that authority through statute. The Fourth Amendment is a restriction on that authority.
The Fourth Amendment says that the right of the people to be secure in their place, in their persons, housings, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation. And what I'm reading into the Fourth Amendment is that the people do have a right to privacy, have right to be secure in their persons, housings, papers, and effects, but I'm also reading into it an implied responsibility of the government to, on occasion, search and seize. Would that be your reading of it also?
Yes.
And of course, upon probable cause, but there are some circumstances where in the hot pursuit or at the time of an arrest, there's some exceptions that have been carved out to where a warrant is not always required to search and seize. Is that correct?
Yes, you mentioned one, the so-called exigent circumstances doctrine, where if you're in the middle of an emergency and you're looking for a gun that a bad guy might have hid, in a car or something, you don't necessarily have to go get the warrant. If you have the factual basis, you can do the search and then have the judge look at it and validate it.
Now, even in a situation where exigent circumstances exist, technology has now brought us to the point where law enforcement or government is preempted from being able to search and seize. Is that correct? Technology has produced this result.
Yeah, I think technology has allowed us to create zones of complete privacy, which sounds like an awesome thing until you really think about it. But those zones prohibit any government action under the Fourth Amendment or under our search authority.
Well, it's actually a zone of impunity, would it not be? A zone where bad things can happen and the security of Americans can be placed at risk.
Potentially, yes, sir.
And that is the situation that we have with end-to-end encryption. Is that not correct?
I think that's a fair description, where we have communications where even with a judge's order can't be intercepted.
Now, you said that you were not a constitutional scholar, and neither am I, but does it seem reasonable that the framers of the Constitution meant to exempt any domain from its authority to be able to search and seize if it's based on probable cause or some exigent circumstance allows for a search and seizure with less than a warrant and a showing of probable cause?
Yeah, I doubt that they imagined the devices we have today and the ways of communicating, but I also doubt that they imagined there would be any place in American life where law enforcement with lawful authority could not go. And the reason I say that is the First Amendment talks about the people's homes. Is there a more important place to any of us than our homes? So from the founding of this country, it was contemplated that law enforcement could go into your house with appropriate predication and oversight. So to me, the logic of that tells me they wouldn't have imagined any box or storage area or device that could never be entered.
So from that standpoint, to be a strict constructionist about the Constitution and the Fourth Amendment, it's ridiculous that anyone would think that we would not be able to take our present circumstances and shape current law to appreciate the niceties of today's practical realities. I know I'm rambling a little bit, but did you understand what I just said?
I understand what you said, sir.
Would you agree or disagree with me?
Time of the gentleman has expired. The director may answer the question.
I think it's the kind of question that democracies were built to wrestle with and that the Congress of the United States is fully capable of wrestling with in a good way.
Well, in
the time of the gentleman,
we have been.
The time of the gentleman has expired.
Thank you.
The chair recognizes the gentleman from Pennsylvania, Mr. Marino, for 5 minutes.
Thank you, Chairman. Mr. Director, it's always a pleasure.
Same, sir.
I'm going to expand a little bit on one of Judge Poe's questions. Is the Bureau asking Apple to simply turn over the penetration code for the Bureau to get into, or that you want the penetration code at your disposal? Do you understand what I'm saying?
As I understand the judge's order, the way it could work out here is that the maker of the phone would write the code, keep the phone and the code entirely in their office space, and the FBI would send the guesses electronically. So we wouldn't have the phone, we wouldn't have the code, and that's my understanding of it.
That's a good point to clarify, because there's a lot of rumors out there. I'm going to switch to the courts a little bit here. Do you see the federal court resolving the warrant issue that the Bureau is presently faced with, whatever way that decision eventually comes down, or should Congress legislate the issue now, if at all?
I appreciate the question. I don't think that's for me to say. I do think the courts, some people have said, so in the middle of this terrorism investigation, why didn't you come to Congress? Well, because we're in the middle of a terrorism investigation.
Yeah, right.
And so I think the courts will sort that out faster than any legislative body could, but only that particular case. The broader question, as I said earlier, I don't see how the courts can resolve this tension between privacy and public safety that we're all feeling.
Another good point. Given that most of our social, professional, and very personal information is on our desktop computers, on our laptops, on our pads, and now more than ever on these things, what is your position on notching up the level at which members of the federal judiciary can approve a warrant to access critically valuable evidence to solve a horrific felony, particularly when fighting terrorism?
Do you mean making the threshold something above probable cause?
No, not the threshold. The federal judicial individual is making this decision. Right now, I understand it's a magistrate. When I was at the state level, we could do some things at the sort of the magistrate level or the district court, but then we had to go to the superior court. And working in the federal system with you, we had to go to one or two different levels. What's your position on that?
I see what you're saying. So instead of having magistrate judges decide these questions, the district court might?
Yeah, and no disrespect to magistrate courts. I'm very good friends with a lot of those brilliant people who will eventually, I know, go to the bench. But from a perspective of the public, that a more narrowly defined, limited number of people making that decision concerning the electronics that we have.
Honestly, Congressman, I haven't thought about that. I agree with you. I have a number of friends who are magistrate judges, and they're awesome, and they think well, and they rule well. I think they're fully capable of handling these issues, but I haven't thought about it well enough to react other than that.
Okay. And just for the record, I've managed a couple of prosecution offices, and I've never gone to the experts, whether it's in DNA or whether it's in these electronics, asked them, did you complete everything that you should have completed?
Thank you, Mr. Marino.
The chair recognizes the gentlewoman from California, Ms. Chu, for 5 minutes.
Director Comey, my district is next to San Bernardino. After the terror attack, we mourned the loss of 14 lives and empathize with the 22 wounded. And there is indeed fear and anxiety amongst my constituents. So our discussion here today is particularly important to the people back home. There are many in our area that want answers, but there are also many that feel conflicted about putting their own privacy at risk. So my first question to you is, under federal law, we do not require technology companies to maintain a key to unlock encrypted information in the devices they sell to customers. Some of the witnesses we'll hear from today argue that if such a key or software was developed to help the FBI access the device used by Syed Farook, it would make the millions of other devices in use today vulnerable. How can we ensure that we're not creating legal or technical backdoors to U.S. technology that will empower other foreign governments in taking advantage of this loophole?
It's a great question. I think that what you have to do is just talk to people on all sides of it who are true experts, which I am not, but I've also talked to a lot of experts, and I'm an optimist. I actually don't think we've given this the shot that it deserves. I don't think the most creative and innovative people in our country have had an incentive to try and solve this problem. But when I look at particular phones, in the fall of 2014, the makers of these phones could open them. And I don't remember people saying the world was ending at that point and that we're all exposed. And so I do think judgments have been made that are not irreversible. But I think the best way to get at it is talk to people about, so why do you make the phone this way and what is the possibility? The world I imagine is a world where people comply with warrants. How they do it is entirely up to them. Lots of phone makers and providers of email and text today provide secure services to their customers, and they comply with warrants. That's just the way they've structured their business, and so it gives me a sense of optimism that this is not an impossible problem to solve. Really, really hard, and it will involve you all talking to the people who really know this work.
Well, I'd like to ask about law enforcement finding technical solutions. I understand that there may be other methods or solutions for law enforcement when it comes to recovering data on a smartphone. Professor Landau argues in her testimony later today that solutions to accessing the data already exist within the forensic analysis community, solutions which may include jailbreaking the phone, amongst others. Or, she says, other entities within the federal government may have the expertise to crack the code. Has the FBI pursued these other methods or tried to get help from within the federal government, such as from agencies like the NSA?
Yes is the answer. We've talked to anybody who will talk with us about it, and I welcome additional suggestions. Again, you have to be very specific. 5C running iOS 9. What are the capabilities against that phone? There are versions of different phone manufacturers and combinations of model and operating system that it is possible to break a phone without having to ask the manufacturer to do it. We have not found a way to break the 5C running iOS 9. And as I said, in a way, this is kind of yesterday's problem, because the 5C, although I'm sure it's a great phone, has been overtaken by the 6 and will be overtaken by others that are different in ways that make this relief yesterday.
So let me ask this, like smartphones, safes can be another form of storage of personal information. Similarly to how technology companies are not required to maintain a key to unlock encryption, safe manufacturers are not required to maintain keys or combinations to locks. Given this, law enforcement has been able to find a way to get into safes under certain circumstances or obtain critical information through other avenues. So how does this differ from unlocking a smartphone? It's clear that technology is outpacing law enforcement's ability to get information from devices like the iPhone, even with a proper warrant. But isn't it the FBI or the law enforcement agency who bears the responsibility to figure out the solution to unlock the code?
I'll take the last part first. Sure, if we can figure it out. The problem with the safe comparison is there's no safe in the world that can't be opened. Right? If our experts can't crack it, we'll blow it up. We'll blow the door off. And so This is different. The awesome, wonderful power of encryption changes that and makes that comparison, frankly, inapt. And so, sure, where law enforcement can appropriately, lawfully figure out how to do it, we will and should. But there will be occasions, and it's going to sweep across, again, with the updating of phones and the changing of apps where we communicate end-to-end encrypted, it's going to sweep across all of our work and outstrip our ability to do it on our own.
Thank you. I yield back.
Chair thanks the gentlewoman. The gentleman from South Carolina, Mr. Gowdy, is recognized for 5 minutes.
Thank you, Mr. Chairman. Director, thank you for your service to the country. And I do appreciate your acknowledgement and that of my colleagues of the difficulty in reconciling competing binary constitutional principles like public safety, national security, and privacy. And I confess up front my bias is towards public safety. Because of this loosely held conviction I have that the right to counsel, the right to free speech, the right to a jury trial just isn't of much use if you're dead. So I reconcile those competing principles in favor of public safety. And my concern, as I hear you testify, is that I have colleagues and others who are advocating for these evidence-free zones. They're just going to be compartments of life where you are precluded from going to find evidence of anything. And I'm trying to determine whether or not we as a society are going to accept that there are certain, no matter how compelling the government's interest is in accessing that evidence, we are declaring right now this is an evidence-free zone. You can't go here no matter whether it's a terrorist plot. Now, I'm not talking about the fiend case. That's a drug case. The case the magistrate decided yesterday in New York is a drug case. Those are a dime a dozen. National security, there's nothing that the government has a more compelling interest in than that. And we're going to create evidence-free zones. Am I missing something? Is that how you see it? That you just can't go in these categories unless somebody consents?
That's my worry and why I think it's so important we have this conversation. Because even I, on the surface, think it sounds great when people say, hey, you buy this device, no one will ever be able to look at your stuff. But there are times when law enforcement saves our lives, rescues our children, and rescues our neighborhoods by going to a judge and getting permission to look at our stuff. And so again, I come to the case of the Baton Rouge 8-month pregnant woman shot when she opens her door. Her mom says she keeps a diary on her phone. We can't look at the diary to figure out what might have been going on in her life. Who is she texting with? That's a problem. I love privacy. All of us also love public safety, and it's so easy to talk about, buy this amazing device, you'll be private. But you have to take the time to think, okay, there's that, and what are the costs of that? And that's where this collision's coming in.
Well, I love privacy too, but I want my fellow citizens to understand that most of us also, in varying degrees, also love our bodies and the physical integrity of our body. But since Schmerber, the government has been able to access orders for either blood against the will of the defendant, or in some instances, surgical procedures against the will of the defendant. So when I hear my colleagues say, have you ever asked a non-government actor to participate in the securing of evidence? Absolutely. That's what the surgeon does. If you have a bullet from an officer who was shot in a defendant, you can go to a judge and ask the judge to force a nurse or surgeon to anesthetize and remove that bullet. So if you can penetrate the integrity of the human body in certain categories of cases, how in the hell you can't access a phone? I just find baffling. But let me ask you this. If Apple were here, and they're going to be here, how would they tell you to do it? If there were a plot on an iPhone to commit an act of violence against, say, hypothetically, an Apple facility, and they expected you to prevent it, how would they tell you to access the material on this phone?
I think they would say what they've said, which I believe is in good faith, that we have designed this in response to what we believe to be the demands of our customers, to be immune to any government warrant or the manufacturer's efforts to get in that phone. We think that's what people want. And that may be so, except I would hope folks will look at this conversation and say, really, do I want that? And take a step back and understand that this entire country of ours is based on a balance. It's a hard one to strike, but it's so seductive to talk about privacy is the ultimate value. in a society where we aspire to be safe and have our families safe and our children safe, that can't be true. We have to find a way to accommodate both.
So Apple, on the one hand, wants us to kind of weigh and balance privacy, except they've done it for us. They have said, at least as it relates to this phone, we've already done that weighing and balancing, and there is no governmental interest compelling enough for us to allow you to try to guess the password of a dead person's phone that is owned by a city government. There's no balancing to be done. They've already done it for us. I just tell you, Director, in conclusion, we asked the Bureau and others to do a lot of things: investigate crime after it's taken place, anticipate crime, stop it before it happens. And all you're asking is to be able to guess the password and not have the phone self-destruct. And you can go into people's bodies and remove bullets, but you can't go into a dead person's iPhone and remove data. I just find it baffling, but I'm out of time.
Gentleman's time has expired. Chair recognizes the gentleman from Florida, Mr. Deutsch, for 5 minutes.
Thank you, Mr. Chairman. Director Comey, thank you for being here. Thank you for your service and that of the men and women who work for you. We're all grateful for what they do. And I just wanted to take a moment before I ask you a couple of questions here to let you know that Bob Levinson, who was an agent for over 20 years, 28 years at the Justice Department, continues to be missing. I want to thank you for what you've done. I want to thank you for the Facebook page in Farsi that you've put up. I'd love a report on the effectiveness and what you've heard from that. And I want to, more than anything else, on behalf of Bob's family, I want to thank you for never forgetting this former agent, and I'm grateful for that.
Thank you, sir. He'll never be forgotten.
Now, I want to agree with Mr. Gowdy that if this were as easy as public safety or privacy, I think most of us, probably all of us, if we had to make the choice, we're going to opt for public safety for the very reason that Mr. Gowdy spoke of. But what I have some questions. What I'm confused about is this: the tool that you would need to take away the dogs, to take away the vicious guard dogs, is a tool that would disable the auto erase. There's some confusion as to whether there's an additional tool that you're seeking that would allow you to rapidly test possible passcodes. Is there a second tool as well?
Yeah, I think there's actually 3 elements to it, and I've spoken to experts, so I hope I get this right. The first is what you said, which is to disable the self-destruct auto erase type feature. The second is to disable the feature that between successive guesses, as I understand iOS 9, it spreads out the time. So even if we got the ability to guess, it would take years and years to guess. So do away with that function. And the third thing is, which is smaller, is set it up so that we can send you electronic guesses, so we don't have to have an FBI agent sit there and punch in 1, 2, 3, 4, 1, 2, 3, like that.
And once they created that, would you expect them, after this case, would you expect them to preserve that or destroy it?
I don't know. It would depend on what the judge's order said. So I think that's for the judge to sort out. That's my recollection.
And so here's the issue. I think that vicious guard dog that you want to take away so that you can pick the lock is one thing. But in a world where we do, I mean, it's true, there are awful people, terrorists, child predators, molesters, who do everything on here, but so do so many of the rest of us. And we would like a pack of vicious guard dogs to protect our information, to keep us safe, because there's a public safety part of that equation as well. And the example of surgical procedures, the reason that I don't think applies here is because in that case, we know the only one doing the surgical procedure is the doctor operating on behalf of law enforcement. But when this tool is created, the fear, obviously, is that it might be used by others, that there are many who will try to get their hands on it and will then put at risk our information on our devices. And how do you balance it? This is a really hard one for me. This isn't either or. I don't see it as a binary option. So how do you do that?
I think it's a reasonable question. I also think it's something the judge will sort out, Apple's contention. which again I believe is made in good faith, is that there would be substantial risk around creating this software. On the government side, count us skeptical, although we could be wrong, because I think the government's argument is that's your business to protect your software, your innovation. This would be usable in one phone. But again, that's something the judge is going to have to sort out. It's not an easy question.
If it's the case, though, that it's usable in more than one phone and that it applies beyond there, then the public safety concerns that we may have, that a lot of us have about what would happen if the bad guys got access to our phones and our children's phones, in that case, those are really valid, aren't they?
Sure. The question that I think we're going to have litigation about is how reasonable is that concern? And slippery slope arguments are always attractive, but I mean, I suppose you could say, well, Apple's engineers have this in their head. What if they're kidnapped and forced to write software? That's why the judge has to sort this out between good lawyers on both sides making all reasonable arguments.
And I worry, just finally, Mr. Chairman, I just worry when we talk about the precedential value, the discussion is taking place wholly within a domestic context. There are countries around the world where we know very well that the governments do their best to monitor what happens in their country, and through people's cell phones are able to squash dissent, are able to take action to throw people in jail and to torture people. And I think that precedential value is something else that we have to bear in mind as we engage in this really important and really difficult debate. And I yield back, Mr. Chairman.
Chair thanks, gentlemen, and recognizes the gentleman from Florida, Mr. DeSantis, for 5 minutes.
Good afternoon, Director Comey. When you're looking at a case like the Apple case, and you want to be able to, as you said, remove the guard dogs and then the FBI go in, are you concerned about preserving the evidentiary value that can then be used, or are you more interested in just getting the information for intel purposes so that you can use that for counterterrorism?
Our hope is to do both, but if we have to choose, we want the information first, and then we'd like it, obviously, to be in a form that could be used if there was a court proceeding against somebody someday.
Well, I guess, are there instances in which maybe a company would provide the data but would provide it to you in a way that you would not necessarily be able to authenticate that in court?
Sure, that happens all the time.
And that's something that the FBI, if that's what you get, then you're fine with that?
It depends upon the case, but in general, that's a tool that we use. Private cooperation where we may not be able to use the information in court.
And in terms of this, the guy in San Bernardino, it wasn't even his phone, and then the owner of the phone has consented for the FBI to have the information. Is that correct?
Right. We have a search warrant for the phone. The guy who was possessing it is obviously dead, and the owner of the phone has consented.
What's the best analogous case to what you're trying to do here? Because people look at it and say, well, you're basically commandeering a company to have to do these things. That's typically not the way it works. So what would you say is the, outside of the technology context, what would be an analogous case?
Well, everyone in the United States, to some degree, has an obligation to cooperate with appropriate authority. The question that the court has to resolve under the All Writs Act is, what are the limits of that? Apple's argument is that might be okay if it requires us to hand you something we've already made to open a phone, but if we're going to make something new, that's beyond the scope of the law. As you know, that's something courts do every day in the United States, trying to understand a law and interpret its scope based on a particular set of facts. So that's what will be done in San Bernardino. In a different context, it's being done in Brooklyn, in the drug case in Brooklyn. I think it's being done in different stages all over the country because in investigation after investigation, law enforcement is encountering these kinds of devices.
Have you, in your cases, have you gotten an order under the All Writs Act to just have a defendant, if you have a search warrant, produce the code?
I don't know of a similar case.
In terms of, I know some of the technology companies are concerned about if they're creating ways to, I guess, penetrate their systems, that's creating like a backdoor. And I guess my concern is terrorists obviously want to operate in a variety of spheres. One of the ways that they get a lot of bang for their buck is cyber attacks. And so if companies were creating more access for law enforcement in some of these situations, would that create more vulnerability for people and be more likely that they were subjective to a potential cyber attack?
Potentially, sure. If there were access tools that got loose in the wild or that could be easily stolen or available to bad people, it's a concern. As I said, a huge part of the Bureau's work is protecting privacy by fighting against those cyber criminals. So it's something we worry about every day.
Well, how would you then provide assurances if you're requesting company to work with you that this doesn't get out into the wild, so to speak?
I think in the particular case, we have confidence, I think is justified, that Apple is highly professional at protecting its own innovation, its own information. So the idea here is you keep it. You figure out how to store it. You even take the phone and protect it. I think that's something they do pretty well. But again, that is something the judge will sort out. Apple's argument, I think, will be that's not reasonable because there are risks around that. Even though we're good at this, it could still get away from us. And the judge will have to figure that out, what's reasonable in that circumstance.
Great. Thank you. I yield back the balance of my time.
Chair thanks the gentleman. Recognizes the gentleman from Illinois, Mr. Gutierrez.
Thank you, Mr. Chairman, and thank you, Director Comey, for coming and being with us here this afternoon. I won't take my 5 minutes, so I'll make a couple of comments, and beginning by saying that I hope that all of the members of the committee would take note that the Director is actually answering our questions, and that is obviously very refreshing in that we get a lot of witnesses here, and if they bring them, we might not like them. If we bring them, they don't seem to like them. And it's good to get information without passing judgment. And I think that's what you've done very well here today. You're not passing judgment on Apple and their motivations. And I think in not questioning people's motivation, it's easier to get a solution. Because once you do that, everybody kind of says, okay, let's get all our defenses up. And really what we need to be doing is defending the American people, not Apple or any company or the FBI for that matter, but defending the American people. So I want to thank you for that. And I just want to suggest that we continue these conversations. I buy a house. I have no reasonable expectation that if you get a warrant, you're going to go into any drawer in my bedroom. When I buy the house, I don't have any expectation of privacy. Once you get a warrant to come, I do expect you to get one. I come from a time when I wasn't quite sure the Chicago police and law enforcement was actually getting warrants in the city of Chicago in the 1960s to get that. So we want to be a little careful and make sure. I'm trusting of you. If you were the FBI agent, I'd say, no problem, Director Comey, come on in. But unfortunately, there are human beings at all the different levels of government, and I just want to say that I'm happy you came, because I don't have that expectation in my car. I don't have that expectation in, I don't use the computer a lot I still write. I don't have any expectation. But the difference is, and I think you've made it, and I think this committee should take it into consideration, we do put a lot of information in these contraptions. And the reason we put them there is because we don't want to put them on a notebook. We want to keep them private. But I don't have any I really don't have any expectation that once I put this, if you have a lawful warrant, that you should be able to get it, even from my computer, if you have a law. I think so I think that's where you're going. Is that where you think, if I heard you right?
I do. I agree with you, except I think the case for privacy is even stronger than you said. You do have a reasonable expectation of privacy in your home, in your car, and in your devices. The government, under our Constitution, is required to overcome that by going to an independent judge, making a showing of probable cause, and getting a warrant. What we need to talk about as a country is we're moving to a place where there are warrant-proof places in our life. And yes, these devices are spectacular because they do hold our whole lives. They're different than a briefcase. They're different than a drawer. So it is a source with a place with a tremendous reasonable expectation of privacy. But if we're going to move to a place where that is not possible to overcome that, that's a world we've never lived in before in the United States. That has profound consequences for public safety. And all I'm saying is we shouldn't drift there. Right? Companies that sell stuff shouldn't tell us how to be. The FBI shouldn't tell us how to be. The American people should say, the world is different. How do we want to be? And figure that out.
Yeah, I think we're on the same place then, because I do have a reasonable expectation of privacy in my home. But if you go to court, you convince the judge, and you overcome it. I've never had any expectation that a court order, because I bought something, I'm going to be able to overcome a court order. So I think we're in the same place. So thank you so much, Director, for coming and sharing time. I hope to share more time with you so we can talk some more. Thank you.
The chair recognizes the gentleman from Iowa, Mr. King, for 5 minutes.
Thank you, Mr. Chairman. Director, thanks for your testimony here and your leadership of the FBI. I'm curious about this from a perspective that has to do with our global war against radical Islamic terrorists. And I have laid out a strategy to defeat that ideology. I would take it back to our ability some years past to be able to identify their cell phones and get into their cell phones in such a way that we also got into their heads, which drove them into the caves and really it diminished a lot of their otherwise robust activity that that Al-Qaeda might have carried out against us. I think that was a successful effort. Now we have global cyber operations going on with, I think by your numbers from a previous report I read, well over 100,000 ISIS activities on Twitter and other cyber activity in a single day. And so I'm interested in how the parameters that have been examined thoroughly by a lot of the lawyers on this panel might apply to an all-out cyber warfare against ISIS and any of their affiliates or subordinates that I think is necessary if we're going to defeat that ideology. And so I'm thinking in terms of if this Congress might diminish, slow down, or shut down access to this phone, it also means access to any other phone that they might be using. They would have a high degree of confidence that they could operate with a level of impunity in the cyber world out there. Do you have any comments you'd like to make on the implications that being locked out of an opportunity to unlock this phone might mean to a global war on terror that could be prosecuted in the next administration aggressively across the fields of cyber warfare? And I would just add to that, for the sake of enumerating them, financial warfare, educational warfare, and human intelligence, and the network that'd be necessary, not just the kinetic activity, to defeat radical Islamic terrorism.
Thank you, Mr. King. This conversation we're having today, and that I hope will continue, is really important for domestic law enforcement, but it has profound implications for, among other things, our counterterrorism work, because since Mr. Snowden's revelations, terrorist tradecraft changed, and they moved immediately to encrypted apps for their communication and trying to find devices that were encrypted, wrap their lives in encryption because they understand the power of encryption. And so there's no place we see this collision between our love for privacy and the security of encryption and public safety than in fighting terrorism, especially ISIL, because for the FBI's responsibility, which is here in the United States, every day we're looking for needles in a haystack, and increasingly the most dangerous needles go invisible to us, because that's when ISIL moves them to an encrypted app that's end-to-end encrypted, and a judge's order is irrelevant there. That's why this is such an urgent feature of our work. It has huge implications for law enforcement, overwhelmingly, but it has profound implications in the fight against terrorism.
Do you get any signals that the American public or the United States Congress is contemplating some of the things that you've discussed here to the depth that it would be a component in the decision-making?
I don't know. I know everybody's interested in this, and everybody, all thoughtful people, see both sides of this and are trying to figure out how to resolve it practically, how to resolve it technically. And the other challenge is, not to make it harder, there is no it. There isn't a single it. There's all different kinds of manifestations of this problem we call going dark. So what I see is people of goodwill who care about privacy and safety wrestling with this. Court cases are important, but they are not going to solve this problem for us.
Let me suggest that, I'll just say I think it's a known and a given that ISIS or ISIL is seeking a nuclear device, and it pretty much said that publicly. If we had a high degree of confidence that they were on the cusp of achieving such capability, and perhaps a capability of delivering it, if that became part of the American consciousness, do you think that would change this debate that we're having here today?
I do worry that it's hard to have nuanced, complicated conversations like this in an emergency and in the wake of a disaster, which is why I think it's so important we have this conversation now, because in the wake of something awful happening, it will be hard to talk about this in a thoughtful, nuanced way. And so I think that's why I so welcome the chairman having this hearing and having further conversations about it.
Thank you, Director. And I would just state that my view is that I want to protect the constitutional rights of the American people. And I'd like to be able to have this framed in law that reflects our constitutional rights. But I would like to have us consider how we might keep a nation safe in the face of this and how we might prosecute a global war against radical Islam, even in the aftermath of a decision that might be made by either a judge or the United States Congress. I thank you, Mr. Chairman. I yield back the balance of my time.
Sure, thanks, gentlemen. The gentlewoman from California, Ms. Bass, is recognized for 5 minutes.
Thank you, Mr. Chair, and thank you, Director Comey, for your time and your patience with us today. I had a town hall meeting in my district on Sunday, and actually a couple hundred people showed up, and it was a general town hall meeting talking about issues that Congress is dealing with. And much to my surprise, this was a burning issue. And many of my constituents came to ask me questions, and I told them that they could suggest some questions, and I would ask you. And maybe you could speak to some of my constituents today so I can send them a clip of your testimony. Basically, in general, they had a hard time believing, I mean, they were not supportive. They don't want, Apple to comply. But they had a hard time believing that the FBI couldn't already do this. And so a couple of the questions were, how have so many others cracked iPhones and shared their findings with videos and how-to articles? And given that you described it not as a backdoor, but getting the dogs, away so that you can pick the lock, their question was, what other intelligence community agencies has the FBI worked with, considering there's at least 12 in the government? Between all of these agencies, how is it that you haven't been able to call the dogs off and pick the lock?
There are actually 16 other members of the U.S. intelligence community. It pains me to say this because in a way, we benefit from the myth that is the product of maybe too much television. The only thing that's true on television is we remain very attractive people, but we don't have the capabilities that people sometimes on TV imagine us to have. If we could have done this quietly and privately, we would have done it. Right? This litigation is difficult. It's especially difficult, as I said, for the people who were victimized in San Bernardino. And so we really can't. As I said, there may be other models and other permutations and combinations where we have different capabilities, but I'm here to tell you here, and again, maybe tonight someone will call us and say, I thought of something. Apple is very good at what it does. It's a wonderful company, makes wonderful products. Right? They have set out to design a phone that can't be opened. And they're darn near succeeding. I think with the 6 and beyond, they will have succeeded. That doesn't make them bad people. That just poses a challenge for us that we're not yet up to meeting without intervention from courts.
Since you can clone iPhone contents to compatible hardware and test passwords on the clones without putting the original at risk, can't you use so-called brute force methods to guess the passcode?
Yeah, not with the, I think this is what Mr. Issa was asking about. I think a lot of tech experts ask, why can't you mirror the phone in some way and then play with the mirror? For reasons I don't fully understand, not possible in this circumstance. So we do want to try and brute force the phone, that is the multiple guesses, but we need first, we'll do that ourselves, but we need removed the auto erase function and the delay between guesses function, which would make us take 10 years to guess it. If we have those removed, we can guess this phone's password with our computing power in 26 minutes, is what we're told, because we have enormous computing power in the U.S. government. But we need to be able to bring it to bear without the phone killing itself.
Thank you. I yield back the balance of my time.
The chair recognizes the gentleman from Idaho, Mr. Labrador, for 5 minutes.
Thank you, Mr. Chairman. Thank you, Director, for being here. Thank you for what you're doing. I know you have a very difficult job as you're trying to balance both security and privacy. I do have a few questions as you're looking at the laws that are in place, like CALEA and FISA or the other different avenues that we're talking about. Something that concerns me is that this is very different than some of the examples have been given here. For example, when you're going into a home, if you're asking for a key, if you go to the landlord, that key's already made. And you can go to the landlord and you can say, I have a warrant here and that key is made. Can you please give me a key for that? Or the method of creating that key, even if the key does not exist, does already exist. This is very different than that. Would you agree?
Yes, you're exactly right. There's a difference between, hey, landlord, you have this spare key. Judge directs you to give it to us. And, hey, landlord, we need you to make a key for this lock.
Yeah.
And that's a legal question as to whether the particular statutory authority we're using here, the All Writs Act, extends to that.
Correct.
We think in the government there's a reasonable argument to be made it does and should. And on the other side, lawyers for Apple argue it doesn't. And that's what the judge will sort out.
But this goes even one step further. In this scenario, the landlord can create the key, has the ability to create the key, and the technology to create the key already exists. In the Apple case, that's not the case. They have never created the key that you're asking for. Isn't that correct?
I don't know whether that's correct or not.
Well, as far as we know, as far as they're letting us know, there's no way for them, as they're telling us, because if not, I think they would be violating the judge's order. If they have an ability to do this, I do agree with you that they would be violating the judge's order. But what they're telling us is that ability does not exist. Isn't that correct?
I think that's right. And they, obviously, their general counsel is a very smart guy. He's here. He can talk about this. But I think what they're saying is, we can do it, but it requires us to sit at a keyboard and write new code that doesn't currently exist.
Correct.
And whether there's a meaningful distinction between that and someone who already has a key legally is something a judge will have to sort out.
See, what concerns me is the old legal maxim that, bad cases make bad law. This is clearly a bad case. We all want you to get access to this phone through legal means because maybe it would uncover some of the problems that we have in the Middle East. Maybe there's some evidence in there that could really lead us to take some terrorists down. I think we are all there, but the problem is that this is a bad case. This is a person who obviously is dead, who has never given his code to somebody else. And I'm concerned that as we're looking down this road, what we're doing is we're opening the door for other things that could actually be detrimental to our safety and security. For example, I think you've testified many times that we're getting hacked all the time. Isn't that correct?
Yes.
So maybe one of the reasons that Apple is refusing to do this or is hesitant to do something like this, because they know that even they get hacked. And when you create that key that doesn't exist at all right now, you're actually opening up every other phone that's out there. Do you see how that could be a concern?
I see the argument. The question the judge will have to decide is that a reasonable argument?
Because I'm sorry, no.
Go ahead.
You said that Apple is they're highly professional in keeping secrets. Would you say that the federal government also has very good people that are highly professional in keeping secrets?
Parts of it.
Me too. Recently, we've learned that there's been a hacking incident at the IRS. Are you familiar with that?
Yes.
So that's what I'm concerned about. The moment that you open up that door, the moment that you open up that key that doesn't currently exist, you're actually allowing all these hackers that are out there, some of them are enemies that are trying to do us harm, whether it's economic harm or whether it's actual terrorism. They're out there looking for ways to actually get into your iPhone, into my iPhone, into everybody else's iPhone. And at some point, that's why you have such a difficult job, is we have to balance that safety and security. Do you think that this capability that you're asking for can only be used pursuant to a warrant?
The capability that the judge has directed Apple to provide? I think that's the way that's the procedural posture of it. There's a warrant and the judge has issued an order.
That's how it is issued right now, but do you think that can only be obtained through a warrant? Or are you seeking to obtain it later through other means other than warrants?
I don't know how we would. If it's in Apple's possession, unless they voluntarily gave it to someone, there have to be judicial process.
Okay.
If they maintained it afterwards.
All right. Thank you very much. I've run out of time. Thank you.
Sure, thanks. Gentleman, recognize the gentleman from Louisiana, Mr. Richmond, for 5 minutes.
Thank you, Mr. Chairman. Before I start, I'd like to enter into the record two articles. One is from the Toronto Star titled, "Encrypted Evidence is Increasingly Hampering Criminal Investigations, Police Say." And another one is from the Baton Rouge Advocate, which says, "The Brittany Mills murder case has put in Baton Rouge in the middle of national cell phone encryption debate." Thank you, Mr. Chairman. And
Let me just say, and Director Comey, you have mentioned the Brittany Mills case a number of times, and I just want to paint the scenario for everyone in the room and put a face with it. This is Brittany Mills, and this is Brittany Mills almost 8 months pregnant with her daughter. In May of last year, Brittany was murdered in my district. She was a mother. She was 8 months pregnant with her second child at the time. Someone came to her door and killed her. And a couple days later, her unborn child or born child also died. And according to her family and her friends, she kept a very detailed diary in her phone. And her family, who are here today, Ms. Mills, Ms. Barbara Mills, will you please stand, and Tia and Roderick, her family would like the phone open so that our district attorney, who is also here today, thank you for standing, our district attorney, who is also here today, Hilla Moore, can use that to attempt to find the murderer who committed this crime. And I guess my question is, we balance privacy, public safety, and criminal justice, that are we in danger of creating an underground criminal sanctuary for some very disturbed people, and how do we balance that?
We are in danger of that. Until these awesome devices, and that's what makes it so painful, they're wonderful. Until this, there was no closet in America, no safe in America, no garage in America, no basement in America that could not be entered with a judge's order. We now live in a different world, and that's the point we're trying to make here. Before we drift to a place where a whole lot of other families in incredible pain look at other district attorneys and say, what do you mean you can't? You have a court order. Before we drift to that place, we got to talk about it, because privacy is awesome. But stopping this kind of savagery and murder and pedophilia and all the other things that hide in the dark spaces in American life is also incredibly important to us. That's why this conversation matters so much, but it's also why we have to talk to each other. There are no demons in this conversation. We care about the same things, but it is urgent, and there's no more painful circumstance that demonstrate it than in the death of that beautiful woman and her baby.
Well, and I do appreciate you saying we have to talk to each other, because just in the small time that I was able to put the representatives of Apple and the district attorney in the room, I think we made some progress and maybe some alternatives, and maybe we'll get somewhere. But it is a very difficult balancing act, and I think the people from Apple are very well-intentioned and have some real concerns. But let me ask you this. I took a congressional delegation trip over to the Ukraine, and when we landed our plane, we were on the runway, and our security advisors came on to the back and said, if you don't want your phone hacked, and people have access to your text messages, your pictures, your emails, and everything else, we advise you to power your phone off and leave it on the plane. And no one is in close enough proximity right now to do it, so if you need to make a call, make a call. But when we get closer to the terminal, you need to power that phone down. So does Ukraine have better technology? Well, they were really worried about Russian hackers. But does Russia have that much of a technology advantage over us that they can get into my phone while I'm on it and it's in my possession, and we can't get into a phone that we have in our possession?
The difference, and I'm going to be careful about what I say in an open setting, is that some countries have different control over their infrastructure and require providers in their country to make accommodations that we do not require here that give them greater surveillance capabilities than we would ever imagine in the United States. That's the first thing. Second thing is, we are a rule of law country. The FBI is not cracking into your phone or listening to your communications except under the rule of law and going to a judge. Those are the two big differences. But countries have capabilities, and in part based on accommodations that device makers and providers have made in those countries that are different than this country.
Thank you, Mr. Chairman. I see my time has expired.
The chair recognizes the gentlewoman from Washington State, Ms. Delbene, for 5 minutes.
Thank you, Mr. Chair, and thank you, Director Comey, for being with us and for all of your time. I've worked my career in technology on email and mobile communications and constantly heard from customers, both consumers and businesses and even the government, to make sure that information was protected and that devices were secure. And in your testimony, you state that you're simply asking to ensure that you can continue to obtain electronic information and evidence. And you seem to be asking technology companies to freeze in place or revert back to systems that might have been easier to access. But don't you think in general that that's much an oversimplification of this issue? Because we all know that bad actors want to exploit vulnerabilities to breaking into any number of things, from a phone, a personal device, to our power grid. These things aren't static, they're changing constantly, and they're getting smarter every day. The bad actors are getting smarter every day, and we need to be smarter every day in terms of protecting information. So in that type of environment, how would you expect a technology company not to continue to evolve their security measures to keep up with new threats that we see?
First of all, I would expect security companies and technology companies to continue to try and improve their security. That's why it's important that all of us talk about this, because it's not the company's job to worry about public safety. Right? It's the FBI's job, Congress's job, and a lot of other folks in the government. So I don't put that on the companies. But the other thing that concerns me a little bit is this sense that if we have a world where people comply with government warrants, it must be insecure. And I don't buy that, because there are lots of providers today of email service, of text service, who have highly secure systems, who, because of their business models, visualize the information in plain text on their servers so they comply with court orders. I have not heard people say their systems are insecure. They simply have chosen a different business model. So I actually don't think it's, again, a lot of people may disagree with me. I actually don't think in the main it's a technological problem. It's a business model problem. That doesn't solve it, but that gets us away from this "it's impossible" nonsense.
But we know more and more. In fact, we're talking about phones today, but we're talking about the growth in the Internet of Things, of more and more personal devices where security will be even more critical. And so it's hard to say you're talking about a world where it's confined to the way the world works today. I think that absolutely is not the situation that we're facing. We're seeing evolution every day, and these are devices that are connected to networks, and information is flowing, and that information might be someone's financial information or personal information that, if it is exploited, would create a security issue itself.
I agree.
So don't you believe that encryption has an important role to play in protecting security?
Vital.
So now when we've talked about what role Congress plays versus what role the courts would play, and you've kind of talked about both in different scenarios. You talked about privacy versus security and that Congress should play a role there, but the courts should decide whether or not there's a security breach if there's a piece of technology that breaks into a device, and whether or not there's a concern that that will be widely available. Yet, the tension isn't really between just privacy and security. It's between security and protecting people's information. And so where do you think Congress plays a role versus the courts when you've talked about both of them in your testimony today?
I think the courts have a job to, in particular cases, interpret the laws that Congress has passed throughout the history of this country to try and decide the government is seeking this relief, does that fit within the statute? That's the court's job, and they're very, very good at it. The larger societal problem we have is this collision that I think you've said well between privacy and security. Very difficult to solve it case by case by case. We have to ask ourselves, how do we want to govern ourselves? Right? If you are a manufacturer of devices in the United States, or you provide communication services in the United States, what are as a country, what are our expectations of you and demands of you? It's hard for me to see that being worked out on a common law basis, honestly. But it's going to be, because the issue is joined every single day in our law enforcement work. If nobody else gets involved, the courts will have to figure it out.
This isn't just an issue of U.S. companies alone, because clearly there's access to technology that could be developed in other countries that we will not have access to, and that's widely available today and people can use. But also, then it is important. We have laws that are centuries and decades old that have not kept up with the way the world works today. And so it is very important that Congress plays a role, because if courts are going to be interpreting those laws, and those laws were written with no awareness of what's happening today, then Congress needs to play a role of making sure we have laws that are up to date and setting that standard so that courts can then follow. Thank you. I yield back, Mr. Chair.
Chair thanks. The gentleman recognizes the gentleman from New York, Mr. Jeffries.
Thank you, Mr. Chairman, and thank you, Mr. Comey, for your presence here today. And as one of my colleagues mentioned, your candor and the open dialogue and communication is much appreciated, and is not always the case with high-level government witnesses and others. You testified today that you don't question Apple's motives in connection with the San Bernardino case. Is that correct?
Correct.
And you also testified that there are no demons in this conversation, true?
Correct. I hope not.
But the Department of Justice has questioned the company's motives in defending the privacy of the American people. Isn't that right?
I don't know they've questioned their motives in the sense that attributed sort of that they're acting with evil intent or something. I think I remember a filing the department said where they think a lot of Apple's position has to do with its market power, which I frankly think is not an illegitimate motive.
In fact, in the motion to compel that you referred to, I believe the prosecutor said that Apple's current refusal to comply with the court's order, despite the technical feasibility of doing so, appears to be based on its concern for its business model and public brand marketing strategy. Is that the statement that you're referring to, sir?
Yeah, and I think that's fair. I bet that's accurate. Apple has a legal obligation, because I used to be the general counsel of a public company, to maximize shareholder value. They're a business, and so I would hope that's part of their motivation, and it's not a bad thing if it's entirely their motivation. Their job is not to worry about public safety. That's our job, all of us in this room who work for the government.
William Bratton is the police commissioner of the New York City Police Department, is that right?
Yes.
That's the largest department in the country?
Yes.
And he's one of the most respected law enforcement professionals in the country. Would you agree with that?
I agree with that very, very much.
Now, at a February 18th press conference in New York City, publicly accused Apple of corporate irresponsibility. Are you familiar with that remark, sir?
I'm not.
Okay. Do you agree with that strident statement? That Apple is engaging in corporate irresponsibility by vindicating its rights?
I don't know that Bill said that, but I'm not going to characterize it that way. I don't think they're acting irresponsibly. I think they're acting as a corporation in their self-interest, which is the engine of innovation and enterprise in this country.
Now, fundamentally, as it relates to the position of those of us who are on the Judiciary Committee, as well as members in the House and in the Senate, guardians of the Constitution, this is not about marketing or corporate irresponsibility, correct? This debate.
I hope not. I mean, I hope part of it is, and that's a voice to listen to, but they sell phones. They don't sell civil liberties. They don't sell public safety. That's our business to worry about.
Right, but in terms of our perspective, this is really about fundamental issues of importance as it relates to who we are as a country, the Fourth Amendment of the United States Constitution, the reasonableness of government intrusion, the rule of law, the legitimate centuries-old concern as it relates to government overreach and the damage that can do. This is fundamentally a big picture debate about some things that are very important to who we are as a country, correct?
I agree completely.
Okay, now, in terms of the technology that's available today, Americans seem to have the opportunity to choose between privacy or unfettered access to data which can reveal the far reaches of their life to a third party, to a government, to a bad actor. Would you agree that there's an opportunity that the technology is providing for Americans to choose privacy?
I don't agree with that framing, because it sounds like you're framing it as we either have privacy or we have unfettered access by bad actors. I don't accept that premise.
Okay, so let me ask a few questions. One of the obstacles to unfettered access is the passcode, correct? The passcode.
Yeah.
Four number or six number passcode.
I naturally quibble because I'm a lawyer, but I'm just stuck on unfettered.
Okay.
Right? One of the obstacles to access to a device.
Let me drop unfettered.
Okay.
The passcode is an obstacle, correct?
Correct.
Now, you can choose a passcode or choose not to activate a passcode, correct?
I think that's right.
Okay. Now, whether you back up your system or not is an issue as it relates to access, correct? In other words, if you don't back up your system, you don't have access, correct? To the cloud.
Yeah, I think if you don't back up your system to the cloud, there's nothing in the cloud that could be obtained by a warrant.
Right. Now, with respect to auto erase, that is a choice that's being made. In other words, you have to actually affirmatively choose auto erase. If you didn't choose it, in this particular case or in any other case, eventually your computer is powerful enough to get access to the data, correct?
I think that's right for the 5C. I think that's right. And folks from Apple could tell you better. I think for the later models, it's not a choice, but I think it's a choice. I'm reasonably confident it's a choice for the 5C.
My time has expired, but I think it's important as we frame this debate to understand that it is actually the American citizen that is choosing on at least 3 different occasions in 3 different ways the value of privacy, and that's something that we should respect as Congress attempts to craft a solution.
Okay.
The chair thanks the gentleman and recognizes the gentleman from Rhode Island, Mr. Cicilline.
Thank you, Mr. Chairman. Thank you, Director Comey, for your service to our country. Thank you for being here today and for the outstanding work of the men and women at the FBI. We all, of course, acknowledge the incredible horrors of the San Bernardino attack. But I think in many ways what we're struggling with is, as Ms. Delbene said, not necessarily security versus privacy, but security versus security. And the real argument that the danger that exists for the misuse of this new technology by foreign agents, by terrorists, by bad actors, by criminals, will actually make us less safe in the long term. And while it may achieve your objective in the short term, in this particular case, that the implications in terms of our own national security and personal security are pose greater dangers. And I think that's what at least I'm struggling with. I appreciate you said this is the hardest question you've confronted, because I think it is a hard one. But the first thing I want to ask is, this is different, would you agree, than all the examples that have been used about producing items in your custody. This is a different kind of warrant because it's actually compelling a third party to produce and create intellectual property which doesn't exist today.
I understand that to be Apple's argument. I don't know enough about the other possible comparisons to give you a thoughtful response. But yes, I understand that.
But it's hard to even imagine how a court ultimately enforces that, because you have to sort of get into the head of the engineers to figure out, did they actually comply with what the government order is directing them to create. I mean, I'm not saying it's not something you're not allowed to ask for, but it is different, it seems to me, than simply asking people to produce that which they are in possession of, custodians of.
Yeah, I see that. I mean, I heard someone earlier say there's a difference between a landlord has a key in his pocket. You say, you got to give us the key, and you don't have one, go make one for that door.
Well, this
and
is
the question
more
for the
than,
judge is, what's the significance?
Not just go make one, because knowing how to make keys exists, but to develop a whole new technology and intellectual property. So I raise that because I think we have to acknowledge it's different and then decide what to do with it. But in addition to that, you've said repeatedly that the government doesn't have the ability to do this already. And as you know, there was a decision yesterday, Magistrate Judge Orenstein, I'd ask unanimous consent that that memorandum in order to be made part of the record, in which he actually...
It already is part of the record.
Okay, which he goes through and says the All Writs Act doesn't apply, CALEA prohibits this by omission, and I think in a very clear way. But in addition to that, he goes on to say that the government argued in an unrelated case that the government actually has the ability to do this, through the Department of Homeland Security investigations, that they are in possession of technology that would allow its forensic technicians to override the passcode security feature on the subject iPhone and obtain the data. So I think this is a very important question for me. If in fact, is it in fact the case that the government doesn't have the ability, including the Department of Homeland Security investigations and all of the other intelligence agencies, to do what it is that you claim is necessary to access this information?
Yes.
Because it's the answer is yes?
That is correct. And I don't know, I think, I could be wrong, but I think the phone in the case from Brooklyn is different. Maybe both the model and the iOS, the operating system is different. But for this, I'm here to tell you, and again, people in the sound of my voice, if you got an idea, let us know. But 5C, iOS 9, we do not have that capability.
Okay.
Again, to disable, the problem is we can get into that phone with our computing power if they take off the auto erase and the delay between guesses function. We will get into that phone.
So do you agree, Director Comey, that if there is authority to be given to do what you're asking, that that authority has to come from Congress?
No, I don't agree with that.
So Where do you think the authority comes from?
Well, the government's already asked the court and made the argument under the court that the All Writs Act vests in the judiciary the ability to order this relief. That's what the court case is going to be about.
If the ruling made yesterday remains, which rejects the notion that the All Writs Act applies and that CALEA, in fact, is congressional intention on this, and the fact that we didn't act on it means you have authorization has not been provided, then would you agree that Congress is the only place that can authorize this? And if so, what would you recommend we do? What would that look like as we grapple with this question? Because I can tell you, for me, having read that, I think CALEA is clear. It doesn't authorize it. It's clear the All Writs Act doesn't. So if there is to be authority, assuming we decide that there should be, it seems it must come from Congress. As the director of the FBI, what do you think what would your recommendation be that would respond to what you see as your needs, but also the national security interests of our country?
Yeah, I'm not prepared to make a recommendation, but I think I get your question now. If the judges are right that you can't use the All Writs Act for this relief, what should Congress do to grant the relief? And I'm not prepared to tell you specifically what to do. I do think it's something that Congress is going to have to wrestle with.
Thank you. I yield back. Thank you, Mr. Chairman. Thank you, Director.
The chair would ask unanimous consent that letters from the Computer Communications Industry Association dated February 29, a statement for the record from Ronaldo Tarish, president of the FBI Agents Association, and a letter dated February 29 from the American Civil Liberties Union all be made a part of the record. Director Comey, you've given us 3 hours. Oh, I'm sorry. I'm jumping the gun here. The gentleman from California, Mr. Peters, is recognized for 5 minutes.
Director Comey, I want to, first of all, thank you, Mr. Chairman. I want to thank you for being here. I wanted to just conclude by saying that I did hear did listen carefully to your opening statement. I thought it was very constructive. I think you appreciate the two objectives we have here, which is to both preserve privacy and to deal with San Bernardino. You've heard the comment, hard cases make bad law. There's still hard cases. And the problem we see in terrorism now is the onesies and the twosies, and the notion that we would have invulnerable communications, I think, is something that we should all be concerned about. I hope that you and the panel to follow you will all be part of a constructive discussion to figure out a way to serve both objectives, and that the lines won't be too hard drawn on either side so that we can do that. And I appreciate, Mr. Chairman, the chance to thank Director Comey for being here, and look forward to the next panel.
Thank you.
Yield back.
Chair, thanks, gentlemen. Director, you've donated 3 hours of your time to our efforts today, or more, I'm sure, in getting ready. So we thank you very much for your participation and for answering a multitude of questions. And we are looking for answers. So if you have more to add to the record later, we would welcome that as well. Thank you very much.
Thank you, sir.
Chairman, would you entertain a unanimous consent while we're changing panels?
I would.
Then I would ask unanimous consent that a letter I received late yesterday from a constituent in the technology business concerning this case be placed in the record. This is Emily Hirsch.
Without objection, will be made a part of the record. We ask the witnesses on the second panel to please come forward and be seated.
We get more water.
And now that Mr. Sewell has been afforded similar attention to the attention previously accorded to Director Comey, I'd ask that the press move back so we can begin this second panel.
Mr. Chairman, I would not assume it was not directed to Ms. Landau, this photography.
Thank you. We welcome our distinguished witnesses for today's second panel, and if you would all please rise, I'll begin by swearing you in. Do you and each of you swear that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you very much. Let the record reflect that all of the witnesses responded in the affirmative. And I'll now introduce the witnesses. Bruce Sewell is Senior Vice President and General Counsel of Apple. Mr. Sewell serves on Apple's legal team and oversees all legal matters, including global security and privacy. Prior to joining Apple, Mr. Sewell was Deputy General Counsel and Vice President of Intel Corporation. He received his bachelor's degree from the University of Lancaster and a JD from George Washington University. Dr. Susan Landau is Professor of Cybersecurity Policy at Worcester Polytechnic Institute. Originally trained as a theoretical computer scientist, Dr. Landau is an expert in cryptographic applications. Within cybersecurity policy, her work focuses specifically on communication surveillance issues. Dr. Landau earned a bachelor's degree from Princeton University, a master's from Cornell University, and a PhD from the Massachusetts Institute of Technology. Our final witness, Mr. Cyrus Vance, Jr., is the District Attorney of New York County. Mr. Vance is currently serving his second term as District Attorney after being re-elected in 2013. He also serves as co-chair of the New York State Permanent Commission on Sentencing. Previously, Mr. Vance worked in private practice and taught at Seattle University School of Law. He is a graduate of Yale University and the Georgetown University Law Center. All of your written statements will be entered into the record in their entirety, and we ask that each of you summarize your testimony in 5 minutes or less. To help you stay within that time, there's a timing light on the table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, that's it. Your time is up. And we'll begin with you, Mr. Sewell. Welcome.
Thank you very much, Mr. Chairman. Thank you, members of the committee, ranking member.
Now make sure that microphone is on and pulled close.
Thank you for that technology. And thank you, Mr. Chairman. It's my pleasure to appear before you in the committee today on behalf of Apple. We appreciate your invitation and the opportunity to be part of the discussion on this important issue, which centers on the civil liberties that are at the foundation of our country. I want to repeat something that we've said since the beginning, that the victims and the families of the San Bernardino attacks have our deepest sympathies. We strongly agree that justice should be served, and Apple has no sympathy for terrorists. We have the utmost respect for law enforcement and share their goal of creating a safer world. We have a team of dedicated professionals that are on call 24 hours a day, 7 days a week, 365 days a year, to assist law enforcement. When the FBI came to us in the immediate aftermath of the San Bernardino attacks, we gave them all the information we had related to their investigation. And we went beyond that by making Apple engineers available to advise the FBI on a number of investigative alternatives. But now we find ourselves at the center of a very extraordinary circumstance. The FBI has asked a court to order us to give them something that we don't have, to create an operating system that does not exist. The reason it doesn't exist is because it would be too dangerous. They are asking for a backdoor into the iPhone, specifically to build a software tool that can break the encryption system which protects personal information on every iPhone. As we have told them, and as we've told the American public, building that software tool would not affect just one iPhone. It would weaken the security for all of them. In fact, just last week, Director Comey agreed, and I think we heard the same here today, that the FBI would likely use this as precedent for other cases involving other phones. We've heard from District Attorney Vance, who's also said that he absolutely plans to use this tool on over 175 phones that he has in his possession. We can all agree this is not about access to one iPhone. The FBI is asking Apple to weaken the security of our products. Hackers and cyber criminals could use this to wreak havoc on our privacy and personal safety. It would set a dangerous precedent for government intrusion into the privacy and safety of its citizens. Hundreds of millions of law-abiding citizens trust Apple's products with the most intimate details of their daily lives. Photos, private conversations, health data, financial accounts, and information about a user's location and the location of that user's family and friends. Some of you may have an iPhone in your pocket right now, and if you think about it, there's probably more information stored on that device than a thief could steal by breaking into your house. The only way we know to protect that data is through strong encryption. Every day, over 1 trillion transactions occur safely over the internet. as the result of encrypted communications. These range from online banking and credit card transactions to the exchange of healthcare records, ideas that will change the world for the better, and communications between loved ones. The U.S. government has spent tens of millions of dollars through the Open Technology Fund and other U.S. government programs to fund strong encryption. The Review Group on Intelligence and Communications Technology, convened by President Obama, urged the U.S. government to fully support and not in any way subvert, weaken, or make vulnerable generally available commercial software. Encryption is a good thing. We need it to keep people safe. We have been using it in our products for over a decade. As attacks on our customers' data become more sophisticated, the tools we need to use to defend against them need to get stronger too. Weakening encryption will only hurt consumers and well-meaning users who rely on companies like Apple to protect their personal information. Today's hearing is entitled Balancing America's Security and Privacy. We believe we can and we must have both. Protecting our data with encryption and other methods preserves our privacy and keeps people safe. The American people deserve an honest conversation around the important questions stemming from the FBI's current demand. Do we want to put a limit on the technology that protects our data, and therefore our privacy and safety in the face of increasingly sophisticated cyber attacks? Should the FBI be allowed to stop Apple or any company from offering the American people the safest and most secure products it can make? Should the FBI have the right to compel a company to produce a product it doesn't already make to the FBI's exact specifications and for the FBI's use? We believe that each of these questions deserves a healthy discussion, and any decision should only be made after a thoughtful and honest consideration of the facts. Most importantly, the decision should be made by you and your colleagues as representatives of the people, rather than through a warrant request based on a 220-year-old statute. As Judge Ornstein concluded yesterday, granting the FBI's request would thoroughly undermine fundamental principles of the Constitution. At Apple, we are ready to have this conversation. The feedback and support we're hearing indicate to us that the American people too. We feel strongly that our customers, their families, their friends, and their neighbors will be better protected from thieves and terrorists if we can offer the best protections for their data. At the same time, our freedoms and liberties we all cherish will be more secure. Thank you for your time, and I look forward to your questions.
Thank you, Mr. Sewell. Ms. Landau, welcome.
Thank you, Mr. Chairman and members of the committee. Thank you very much for the opportunity to testify today. The FBI has pitched this battle as one of security versus privacy, but as a number of the members have already observed, it's really about security versus security. We have a national security threat going on, and we haven't solved the problem at all. What have smartphones got to do with it? Absolutely everything. Smartphones hold our photos and music, our notes and calendars, much of that information sensitive, especially the photos. Smartphones are increasingly wallets, and they give us access to all sorts of accounts, bank accounts, Dropbox, and so on. Many people store proprietary business information on their smartphones, even though their personal smartphones, even though they know they shouldn't. Now, NSA will tell you that stealing login credentials is the most effective way into a system. In fact, Rob Joyce of the Tailored Access Operation said so in a public talk a month ago. Here's where smartphones are extremely important. They are poised to become authenticators to a wide variety of services. In fact, they're already being used that way, including at some high-placed government agencies. Now, District Attorney Vance will tell you that has said that large-scale data breaches have nothing to do with smartphone encryption, but that's not true. Look at today's New York Times, where there's a story about the attack on the Ukrainian power grid. How did it start? It started by the theft of login credentials of system operators. We've got to solve the login authentication problem, and smartphones are actually our best way forward to do it, but not if it's easy to get into the data of the smartphones. Now, the committee has already observed that there are many phones that will go through the process of being unlocked, not just the one in San Bernardino. And what that means for Apple is that it's going to have to develop a routine to do so. Now, what happens when you sign a piece of code to update a phone, and you're signing a piece of code that's an operating system or firmware, you do it once. You do it occasionally. It's a whole ritual, and they're very senior people involved. But if you're dealing with phones that are daily being updated in order to solve law enforcement cases, then what happens is you develop a routine. You get a web page. You get a low-level employee to supervise it. and then it becomes a process that's easy to subvert. I have lots of respect for Apple's security, but not when it becomes a routine process to build an update for a phone. And what will happen is organized crime or a nation state will do so using an update to then hack into a phone, maybe the phone of the Secretary or the Chief of the Federal Reserve, maybe a phone of an HVAC employee who's going to go service a power plant. What we're going to do is decrease our security. That's the security risk that's coming from the requests. Now, I get that law enforcement wants data protection that allows them access under legal authorization. But an NSA colleague once remarked to me that while his agency had the right to break into certain systems, no one ever guaranteed that that right would be easy to do so. The problem is when you build a way in for someone who isn't the owner to get at the data, well, you've built a way in for somebody else to get in as well. Let me go to CALIA for a moment. CALIA is a security nightmare. I know that Congress didn't intend it that way, but that's what it is. If you'll ask the signals intelligence people, they'll tell you there are many ways for nefarious sorts to take advantage of the opening offered by law enforcement. Instead of embracing the communications and device security we so badly need, law enforcement has been pressing to preserve 20th century investigative techniques. Meanwhile, our enemies are using 21st technologies against us. The FBI needs to take a page from the NSA. You may recall that in the late 1990s, the NSA was complaining it was going deaf from encrypted calls. Well, they've obviously improved their technology a great deal. According to Mike McConnell, from that time until now, NSA has had better SIGINT than any time in history. What we need is law enforcement to develop 21st century capabilities for conducting electronic surveillance. Now, the FBI already has some excellent people and expertise, but FBI investment and capacity is not at the scale and level necessary. Rather than asking industry to weaken protections, law enforcement must instead develop the capability for conducting sophisticated investigations themselves. Congress can help. The FBI needs an investigative center with agents with deep technical understanding of modern telecommunications technology, and also, because all phones are computers, deep expertise in computer science. There'll need to be teams of researchers who understand various types of fielded devices. They'll need to know where technology is and where it will be in 6 months, and where it'll be in 2 to 5 years, communications technology in 2 to 5 years, so that they can develop the surveillance technologies themselves. Expertise need not be in-house. The FBI could pursue a solution where they develop some of their own expertise and closely manage contractors to do some of the work. But however the Bureau pursues a solution, it must develop modern state-of-the-art capabilities. It must do so rather than trying to get industry to weaken security. Correct. Your job is to help the FBI build such capabilities, determine the most efficient and effective way that such capabilities can be utilized by state and local law enforcement, for they don't have the resources to develop that themselves, and to also fund that capabilities. That's the way forward that does not put our national security at risk. It enables law enforcement investigations while encouraging industry to do all it can do to develop better, more effective technologies for securing data and devices. That was a win-win and where we should be going. Thank you.
Thank you, Ms. Landau. Mr. Vance, welcome.
Thank you. Good afternoon, Chairman Goodlatte, Ranking Member Conyers, and members of the House Judiciary Committee. Thank you so much for allowing me to participate today. I'm testifying as a district attorney, but on behalf of the National District Attorneys Association. And I'm very grateful for you giving us the opportunity to be here, because much of the discussion in the prior panel and in the comments by the other speakers here has been about the federal government and about the issue of security and cyber crime in the federal context. But it's important, I think, for all us to recognize that state and local law enforcement agencies handle 95% of the criminal cases each year around the country. So we have a very deep interest in the subject matter of this hearing today, and thank you for letting us participate. Apple and Google's decision to engineer their mobile devices to, in essence, be warrant-proof has had a real effect on the traditional balance of public safety versus privacy under our Fourth Amendment jurisprudence. And I agree with the comments, I think, of everyone here, including the many members of the House, that we really need Congress to help solve this problem for us, and it's why it's so important that you're undertaking this effort. But I think in looking at this issue, there are some basic facts from the state law perspective that really are very important in this debate, but are not in dispute. And number one, As Tim Cook said in his open letter to his customers of Apple of February 16 of this year, smartphones, led by iPhone, have become an essential part of our lives. Nothing could be more true. We are all using our cell phones for every aspect of our lives. Number two is that smartphones are also essential to criminals. Our office investigates and prosecutes a huge variety of cases, from homicide to sex crimes, from international financial crime, and including terrorism cases. And criminals in each of those cases use smartphones to share information, to plan and to commit crimes, whether it's through text messages, photographs, or videos. Number three, criminals know that the iOS 8 operating system is warrant-proof. Criminals understand that this new operating system provides them with a cloak of secrecy. And they are, ladies and gentlemen, quite literally laughing at us. And they are astounded that they have a means of communication totally secure from government reach. And I don't ask you to take my word for it. In one lawfully recorded phone conversation from Rikers Island in New York, an inmate talking about the iOS 8 default device encryption called it, and I'm quoting, a gift from God. Number four, the encryption Apple provided on its mobile devices prior to iOS 8, that is before October 2014, was represented to be both secure for its customers and, importantly, was amenable to court-authorized searches. We know this because Apple told us this. Apple characterized its iOS 7 operating system as the ultimate in privacy. It touted its proven encryption methods and assured its users that iOS 7 could be used with confidence in any personal or corporate environment. During the time when iOS 7 was the operating system, Apple also acknowledged, I think importantly, its responsibility to help, again in Apple's own words, police investigating robberies and other crimes, searching for missing children, trying to locate a patient with Alzheimer's disease, or hoping to prevent a suicide, ending quote. So Apple's experience, I believe, with iOS 7 demonstrated that strong encryption and compliance with court orders are not mutually exclusive. Default device encryption has had a profound impact on my office and others like it. In November of 2015, my office published a white paper on public safety and encryption. And at that time, there were 111 iPhones from which we were locked out, having obtained search warrants for those devices. Now, 2.5 months later, when we submitted our written testimony for this committee, the number was 175. Today, it is 205, which represents more than 1 out of 4 of the approximately 700 Apple devices that have been analyzed by our office's own cyber lab since the introduction of iOS 8. And of course, that problem isn't just in Manhattan. Prosecutors in Houston have been locked out of more than 100 iPhones last year, 46 in Connecticut, 36 in Chicago since January, and those are just a few of the thousands of phones taken into evidence each year around the country. So centuries of jurisprudence that have been talked about today have held that no item, not a home, a file cabinet, a safe, or even a smartphone, is beyond the reach of a court-ordered search warrant. But the warrant-proof encryption today gives 2 very large companies, we believe, functional control over the path to justice for victims of crime, including who could be prosecuted and, importantly, who may be exonerated. So our point, Mr. Chairman, is that we believe this line being drawn between public safety and privacy is extremely important. It's affecting our lives. It's affecting our constituents' lives. And we believe that you should be drawing it. And we ask you to address this problem quickly. Time is not a luxury for state and local law enforcement. Crime victims or communities can afford. Our laws require speedy trials. Criminals have to be held accountable, and victims are, as we speak, and we know in this audience, asking for justice.
Thank you, Mr. Vance. We'll now proceed with questioning of the witnesses under the 5-minute rule, and I'll begin by recognizing myself. Mr. Sewell, Director Comey created a dichotomy between this being a technology problem or a business model problem, and said that Apple was addressing this as a business model problem. Is that a fair contrast, or is this something else?
It's by no means a fair contrast, Mr. Chairman. I've heard this raised before. It was raised in New York. It's been raised in San Bernardino. And every time I hear this, my blood boils. This is not a marketing issue. That's a way of demeaning the other side of the argument. We don't put up billboards that talk about our security. We don't take out ads that market our encryption. We're doing this because we think that protecting the security and the privacy of hundreds of millions of iPhone users is the right thing to do. That's the reason that we're doing this. And to say that it's a marketing ploy or that it's somehow about PR really diminishes what should be a very serious conversation involving this Congress, the stakeholders, the American people. Just with respect to the New York case, Judge Orenstein last night took on this issue head on, and he said in footnote 14 on page 40, he said, "I reject the government's claim. I find Apple's activities and the position that they are taking conscientious and not with respect to PR or marketing."
Director Comey and Mr. Vance seems to suggest that the security provided by encryption on prior devices is fine, but advancing encryption technology is a problem. What do you think about that?
So it's important to understand that we haven't started on a path of changing our technology. We haven't suddenly come to the notion that encryption, security, and privacy are important. At Apple, this began back in 2009 with our encryption of FaceTime and iMessage. We've been on a path from generation to generation as the software and the hardware allow us to provide greater security and greater safety and privacy to our customers. What happened between iOS 7 and iOS 8 was that we were able to transform the encryption algorithm that is used within the software and the hardware of the phone to provide a more secure solution.
We are moving to end-to-end encryption on many devices and apps, not just Apple iPhones. Why is that happening?
I think it's a combination of things. From our perspective at Apple, it's because we see ourselves as being in an arms race with criminals, cyber terrorists, hackers. We're trying to provide a safe and secure place for the users of our devices to be assured that their information cannot be accessed, cannot be hacked or stolen. So from our perspective, that end-to-end encryption move is an effort to improve the safety and security of our phones. From the terrorist perspective, I think it's an effort to communicate in ways that cannot be detected. But the terrorists are doing this independently of the issues that we're discussing here today.
Now, if the FBI succeeds in getting the order that is in dispute that Apple has appealed to a final resolution, however long that takes, and they then get Apple to develop this device that will allow the 10 times and your, by the way, all of us here, we can't turn that off. So
we can show you how to do that.
Well, but inside our firewall here, we can't do that. So we understand the reason, but that creates a separate vulnerability, does it not, for people whose device falls in somebody else's hands? They could willfully try 10 times and erase whatever hasn't been backed up on the device. But be that as it may, if they were to get you to develop that code and apply it and then to crack the 4-digit code to get into the device, once they get in there, they could find all kinds of other restrictions that Apple has no control over, right? With regard to apps that are on the phone, with regard to various other communications features that the consumer may have chosen to put on there. Is that correct?
That's absolutely right, Mr. Chairman. One of the most pernicious apps that we see in the terrorist space is something called Telegraph. Telegraph is an app that can reside on any phone. It has nothing to do with Apple. It can be loaded either over the internet or it could be loaded outside of the country. And this is a method of providing absolutely uncrackable communications. If what happens here is that Apple is forced to write a new operating system to degrade the safety and security in phones belonging to tens or hundreds of millions of innocent people. It will weaken our safety and security, but it will not affect the terrorists in the least.
Thank you very much. My time has expired. The gentleman from Michigan, Mr. Conyers, recognized for 5 minutes.
Thank you, Mr. Chairman, and welcome to the witnesses. Let me start off with Professor Landau. Director Comey has just testified that until the invention of the smartphone, there was no closet, no room, no basement in America that the FBI couldn't enter. Did encryption exist before the invention of the iPhone?
Encryption has existed for centuries, and in particular there have been fights over encryption and the use of encryption in the 70s about publication, in the 80s about whether NIST or the NSA would control the development of encryption for non-national security agencies, in the 90s about whether there would be export controls on devices with strong encryption. The White House changed those rules in 2000. We expected to see widespread use of strong encryption on devices and on applications. And the technologist's response to Apple is, what took you guys so long? How, in the face of all the cybersecurity problems that we've had, did it take industry so very long to do this?
Well, as our technical expert, let me ask you this. Is there any functional difference between asking Apple to break its own encryption and what the FBI has demanded in California?
I'm sorry, asking Apple to break, I don't quite understand the question.
All right.
What Apple is being asked to do is to subvert the security controls and go around. So it's not breaking the encryption, but it's subverting its own security controls.
Right.
And is there any functional difference between that and?
And what the FBI has demanded in California?
What it's demanded in California is that Apple subvert its own security controls.
Mm-hmm. Let me ask Mr. Bruce Sewell the same question. What is the functional difference between ordering Apple to break its encryption and ordering Apple to bypass its security so the FBI can break the encryption?
Thank you, Ranking Member. Functionally, there is no difference. What we're talking about is an operating system in which the passcode is an inherent and integrated part of the encryption algorithm. If you can get access to the passcode, it will affect the decryption process itself. What we're being asked to do in California is to develop a tool which does not exist at this time, that would facilitate and enable the FBI in a very simple process to obtain access to the passcode. That passcode is the cryptographic key. So essentially, we are throwing open the doors and we are allowing the very act of decryption to take place.
I was hoping you'd go in that direction. Let me ask you this. There's been a suggestion that Apple is working against law enforcement and that you no longer respond to legal process when investigators need your assistance. Is that accurate?
It's absolutely false. As I said in my opening statement, we care deeply about the same motivations that motivate law enforcement. The relationship with law enforcement falls within my shop at Apple. The people that we have who assist law enforcement every day are part of my team, and I'm incredibly proud of the work they do. We have dedicated individuals who are available around the clock to participate instantly when we get a call. As we've discussed a little bit earlier in Director Comey's...
I want to squeeze in one more question before my time runs out.
All right, I'll try to be very quick. We do everything we can to assist law enforcement, and we have a dedicated team of people who are available 24/7 to do that.
Why is Apple taking this stand? What exactly is at stake in the San Bernardino case?
This is not about the San Bernardino case. This is about the safety and security of every iPhone that is in use today. And I'd like to address one thing that Director Comey raised. There's no distinction between a 5C and a 6 in this context. The tool that we're being asked to create will work on any iPhone that is in use today. It is extensible, it is common, the principles are the same. So the notion that this is somehow only about opening one lock, or that there's some category of locks that can't be opened with the tool that they're asking us to create, is a misnomer. It's something that we needed to clarify.
Thank you for your responses.
The chair recognizes the gentleman from Wisconsin, Mr. Sensenbrenner, for 5 minutes.
Thank you very much, Mr. Sewell. I think you know that I have been one of the privacy hawks on this committee. And the whole debate over the USA Freedom Act was whether the NSA should go to court and get some type of an order or a warrant specifically naming the person or persons whose data is requested. Here, the FBI, has done that. In your prepared testimony, you said that questions about encryption should be decided by Congress rather than through a warrant based on a 220-year-old statute. I'd point out to you the Bill of Rights is about of the same age. Now, the FBI is attempting to enforce a lawful court order. Apple has every right to challenge that order, as you have done. But why is Congress and not the courts the best venue to decide this issue?
Congressman, I think that ultimately Congress must decide this issue. So I'm completely in support of the position that you're articulating. I think we find ourselves in an odd situation in a court in California because the FBI chose to pursue, in an ex parte fashion, a warrant that would compel Apple to do something. We view that not as an extension of the debate, not as a way to resolve this issue. We view that as a way to cut off the debate. If the court were to grant the relief that the FBI is seeking, we would be forced to do the very thing which we think is at issue and should be decided by the American people. We'd be forced to create the tool.
Now, what's your proposed legislative response? Do you have a bill for us to consider?
I do not have a bill for you to consider.
Okay, thank you. That answers that. Now, the FBI has provided some fairly specific policy proposals to ensure that law enforcement can access encrypted data with a warrant. What policy proposal would Apple support? You don't like what the FBI said. What's your specific response?
What we're asking for, Congressman, is a debate on this. I don't have a proposal. I don't have a solution for it. But what I think we need to do is to give this an appropriate and fair hearing at this body, which exists to convene and deliberate and decide issues of legislative importance. We think that the problem here is we need to get the right stakeholders in the room. This is not a security versus privacy issue. This is a security versus security issue, and that balance should be struck, we think, by Congress.
Well, let me make this observation, having dealt with the fallout of the Snowden revelations and the drafting and garnering support of the USA Freedom Act. I can tell you, I don't think you're going to like what comes out of Congress.
Congress, we will follow the law that comes out of this process. We certainly understand.
Okay, well, the thing is I don't understand. You don't like what's being done with a lawfully issued warrant. And most warrants are issued on an ex parte basis, where law enforcement submits an affidavit before a magistrate or a judge, and the judge determines whether the allegations of the affidavit are sufficient for the warrant to issue. Now, you're operating in a vacuum. You've told us what you don't like. You said that Congress ought to debate and pass legislation. You haven't told us one thing about what you do like. When are we going to hear of what you do like so that Apple has a positive solution to what you are complaining about? You said It's Congress's job to do it. Now, we won't shirk from that. This hearing, is a part of this debate. The FBI has provided some policy suggestions on that. You haven't said what Apple will support. So all you've been doing is saying no, 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 no. Now, our job in Congress, honestly, as we did with the Freedom Act and as we are doing with the Electronic Communications Privacy Act update, is to balance our belief that there should be privacy for people who are not guilty or suspected of terrorist activity, and that there should be judicial process, which there has been in this case. And, I guess that what your position is, because you don't have anything positive, is to simply leave us to our own devices. Well, we'll be very happy to do that, but I can guarantee you aren't going to like the result. I yield back.
Congressman, I do think we have said what we stand for and what we believe is the positive place.
Yeah, no, the thing is you've asked Congress to do something. And I asked you what Congress should do. You said we have nothing. Then I said the FBI has provided specific policy proposals to ensure law enforcement is able to get this information. Now, here we're talking about the iPhone of a dead terrorist that was not owned by the terrorist, but was owned by San Bernardino County. Now, the thing is that I don't have a government iPhone. I have my own iPhone, which I use extensively, but the terrorist had, a government iPhone, which belonged to the government. I think the government, San Bernardino County specifically, would like to get to the bottom of this, and you're resisting it. I've said my piece.
Time of the gentleman has expired. The gentleman from New York, Mr. Nadler, is recognized for 5 minutes.
Thank you, Mr. Chairman. Let me begin by welcoming my constituent and the great District Attorney of New York County, Cy Vance, and saying that I appreciate his enlightenment of the District Attorney's views of this dilemma that we all face. Let me also suggest, in answer to Mr. Sensenbrenner's questions, that I assume that Apple may have legislative suggestions for us after the courts come out with their determinations, and Apple decides they like their determinations or they don't like their determinations, at which point Apple and a lot of other people and institutions, I assume, will decide on specific legislative proposals. And it may very well be that this Congress will wait to see what the courts do, but we will see. Let me begin my questions. District Attorney Vance, Director Comey suggested earlier today that the relief sought by the FBI is limited to this one device, running this particular operating software in this one case. Now, I gather that you've mentioned you have over 200 phones faced with a similar problem, that you don't really think that this case will be limited to the one device. That obviously it's going to set a precedent, maybe not the only precedent, for a large class of devices, including the ones that you're interested in.
There may well be an overlap between action in federal court, where the FBI is in litigation, and in state court. I do believe that what we should be seeking collectively is not a phone-by-phone-by-phone solution to accessing devices and the contents when there's probable cause. We should be creating a framework in which there are standards that are required for a court to authorize access to a device, and that it's not based upon litigation as to whether you can get into West Coast phone or an East Coast phone.
I assume that eventually either the courts will set one standard or Congress will have to consider it.
Yep.
Professor Landau, several of your colleagues recently published the results of a survey of over 600, and this is similar to a question I asked Director Comey. Several of your colleagues recently published the results of a survey of over 600 encryption products that are available online. More than 400 of these products are open sourced and made or owned by foreign entities. If Congress were to pass a law, or for that matter, if the courts were to impose a requirement that forcing U.S. companies to provide law enforcement with access to encrypted systems, would that law stop bad actors from using encryption from open sources or foreign sources?
Absolutely not. Absolutely not. And what Apple's product does is it makes encryption easy by default. And so it means that, as I said, the secretary to the chair of the Federal Reserve, the HVAC employee, the chief of staff in your office, of course, your office should be protected anyway, but the regular person using a phone has the phone secured. What the change, if Congress were to pass a law prohibiting use of encryption on Apple phones, or however you wouldn't say it just for Apple, what it would do is it would weaken us, but not change it for the bad guys.
And if someone purchased a phone from a foreign company, it could have the encryption that we prohibited an American company from creating?
That's, if someone purchased a foreign phone, if somebody can just download the app from abroad. They don't have to buy a foreign phone. They can just download the app from anywhere.
And let's assume that Congress decided to prohibit purchase of foreign encryption systems. Is there any practical way we can enforce that?
No. No. I mean, you would have to start inspecting so much as it comes over the internet that it becomes an intrusive.
So what you're saying is that we are really debating something that's undoable.
That's right. And we were there 20 years ago, which the open source issue was part of the reason for the U.S. government's change in export controls, which is part of what enabled.
Okay, let me ask two very quick questions before my time runs out. Mr. Sewell, the Eastern District Court yesterday, in its ruling that's been referred to, cited no limiting principle to the legal theory behind the FBI's request as a reason to deny the order. Is there a limiting principle in the San Bernardino case?
Absolutely none, Congressman.
None. So it can be expanded indefinitely. And finally, Mr. Sewell, your brief, Apple's brief to the court lays out several constitutional concerns. Is computer code speech? Is it protected under the First Amendment? What are the First and Fifth Amendment questions? Well, let me just ask, what are the First and Fifth Amendment questions does this case raise? We've been talking about statute, but let's ask about First and Fifth Amendment questions.
Right. Good question, Congressman. And bear in mind that what we're being asked to do is to write a brand new computer code, write a new operating system. The law with respect to the applicability of computer code to speech, I think, is well established. So this is a compelled speech by the government for the purpose of the government.
Which is a First Amendment problem.
Which is absolutely a First Amendment problem. And bear in mind that this is speech which Apple does not want to make. This is our position. On the Fifth Amendment, the issue is conscription. The issue is forced activity, forced labor.
Does anybody else in the panel want to comment on that question? If not, thank you. My time has expired, Mr. Chairman.
The gentleman from California, Mr. Ice, is recognized for 5 minutes.
Thank you, Mr. Chairman. And I'll pick up where you left off on forced labor. Do you know of any place in our history in which, except in time of war, when things are commandeered and people are told do that, or when police are in hot pursuit, do you know a time in which people were forced to apply their inventive genius against their will?
Congressman, I'm not aware of it. The steel cases during the war are the ones that were the most applicable.
Sure, and I certainly understand a different time and a different set of circumstances. Now, I want to do two things. So, Ms. Landau, I'm going to come to you first. Your expertise is encryption. You were probably very young, but you remember 20 years ago the argument, wasn't it the FBI and then the late Mike Oxley and others that were championing that if we allowed more than 256-bit encryption, then the FBI couldn't easily decode it, and that would be the ruin of their investigations.
Right, and what you get instead is over the last 20 years, the NSA has increasingly supported the secure technologies for private sector communications infrastructure, including the 256-bit algorithm.
Okay, I'm going to ask a quick question, and it's old technology, because I'm very good with analog world, but this happens to be a January 29, 2015 patent that's already in the record, and it's a patent on basically self-destructing the contents inside if someone tries to forcibly open it. Now, the funny thing is I was looking for the old patents going back decades and decades because the military and others have used these. They've had acids and even more punitive, if you will, responses inside when we wanted to secure it. It's not a new technology, but there's a new twist on it. aren't we, in a sense, the equivalent of saying, well, you can make something that destroys the documents, but then you have to tell us how to defeat it?
That's exactly right.
Okay, and I'm looking and saying that there's no history in that, but we've had plain safes for a very, very long time. This isn't new. Do you know of any shredder company that's been told that they have to show you how to reassemble what they've shredded?
I don't study shredding companies, but I'd be very surprised if there were.
Mr. Vance, have you ever ordered a shredding company to put the paper back together, use their inventive genius?
Of course I haven't, Congressman.
Okay,
But
you're asking in this case for somebody to create a product for your service, and I want to focus on that, and I'll get to you, I promise. But Mr. Swallow, I'm going to look at you as the representative of one of the great technology companies in our country. Apple gets its great technology people, I assume, from Stanford and MIT and other great universities, right?
We do, yes indeed.
And you don't get all the graduates, right?
No, we don't. We wish we did.
So when I was talking to the director and saying, well, if you take, and it's a hypothetical, my level of knowledge is way less than any of your folks and probably any of the FBI's, but if you take this hard drive, solid-state hard drive, you pull it apart, and he even used the word mirroring. Obviously, he'd had some discussion at some point, and you make as many images as you want. Then you have a true original that even if the self-destruct occurs, that original, you throw it away, you take another one. So that part of what he's asking you to do, they can do themselves by pulling the chip out and having it imaged, if you will, in all likelihood. We're not saying for sure, but he hadn't checked it. So that's a possibility. Is that right?
I believe so. We don't know what the condition of the phone is, and we don't know what the condition of the RAM is.
And of course, we're not really talking about one phone. We know that. We're talking about thousands of phones. And as I understand the technology used in your chip is you have burnable traces in your chip. So randomly or in some way, when you're producing each chip, you burn traces which create the encryption algorithm, and it's internal. So the chip has its algorithm separate from the software. But that chip, when interfacing with an image, if you keep giving it new images, that's the part that changes. So isn't it at least conceivable that as to that phone, and perhaps the 175 in New York and others, that the FBI or the NSA could in fact come up with an elegant brute force attack that would work on your phones and also would work on hundreds of other types of phones around the world, and that technology with, if you will, those brilliant young minds from Stanford, MIT, and Kent State, my alma mater, you know, could in fact produce something that would not be available to the public, they would have control over, and they would be able to make it more universal than just trying to go through your source code, which I understand, is it correct, they've never asked for, is that right?
We've never been asked for our source code.
Okay. Mr. Chairman, if anyone else wants to opine on it, I would appreciate they be able to.
Chair thanks the gentleman and recognize the gentlewoman from California, Ms. Lofgren, for 5 minutes.
Well, thank you very much. I think this hearing is very helpful, and just to get it on the record, Mr. Sewell, I mean, you're not objecting. Well, let me step back. If you have something and you are served with a warrant, you give that something up. Is that correct?
That's absolutely correct. Yes.
So the issue here is you don't have it, you got no way to get it, therefore you can't give it, right?
That's correct.
Now, if it were possible to do something that would get just this one thing without opening the door to everybody else's stuff, would you have a problem with that?
Let me
rephrase that, because you're in court.
Sure.
That would be a different issue than breaking encryption generally, wouldn't it be?
The best analogy that I can come up with, and I've been struggling with, is how do we create the right kind of analogy for this situation? If Apple had a box somewhere that we could guarantee, we could assure 100% certainty that anything that was put in that box was not susceptible to thievery, to attack, to corruption. Right. If we had such a place in the world, we wouldn't be here today. Because right. What we would have done is gone to our customers and we would have said, give us your passwords. We can absolutely 100% protect them. And then if you lose your phone, if you need our help, we can just give you the passcode.
But you didn't do that because you can't guarantee that, which is why you encrypted this phone.
Exactly right. And now the bizarre situation is that essentially the FBI is saying, we all realize it's silly that everybody would give you your password, but instead we want you to build a tool that will get those passwords, and we're telling you can put that tool in this box that doesn't exist.
Let me ask you this. Is it possible, theoretically, to create code that would preclude you from creating a system that would allow you to defeat the 10 try erase function?
We could write a program that would suppress that protective method.
So that you couldn't do what it is you're being asked to do.
Right, we're being asked to do three things, but it is capable. We're capable of doing those three things. The issue is what's the consequence of doing it.
Right, but the question is also, I mean, this hearing caused me to go in and turn on the 10 erase function, which I had neglected to do before the hearing. Thank you very much. But as you go forward, people are insecure about what's safe.
Absolutely.
And for example, you don't have, and I think for good reason, what's in iCloud is not encrypted. Is it possible to encrypt the data in iCloud?
Yes, actually in the iOS 8 and 9 generation, we have encrypted the iCloud data. It's encrypted in a different way than it was before, and we think in a more secure way.
Right, but you can still provide access to that.
It is encrypted in a different way, and so...
But you could change that if you wished.
Yes.
Now, let me ask you this, Dr. Landau. You were involved with that paper that was published, I think, last year. Thank you. That was an excellent paper. And I think for anybody who has, it's dense. I had to read some pages two and three times to understand it. But if for anybody, and actually I'd ask unanimous consent, Mr. Chairman, to put that paper in the record from the cryptographers.
Without objection, it will be made a part of the record.
If you just go to the questions at the end, you see that this is a fool's errand. We'll never be able to do what is being asked of us by the FBI. It's a practical matter. It's just not achievable. But I'm interested in your take on, Director Comey said, they don't want the master key. They just want this one bypass on security. Isn't that exactly the same?
It's wrong, and it's just as Bruce Sewell said. Once they've built that software works for other phones. Of course, it has to have the serial number of the particular phone, so Apple has to sign, has to take the software, put in a new serial number, sign it so the new phone accepts it, and that's where all the security risks comes in, because it becomes a routine process, and as I mentioned during my remarks, routine processes get subverted.
I'll ask the final question. Mr. Sewell, it was asked earlier by my colleague, Mr. Richmond, about whether these other countries have better security than we do. If I take my iPhone with the current operating system to Russia or China, can they break into it?
With respect to the phone itself, we believe that the encryption we've provided in iOS 8 makes that effectively impossible. With respect to the things that are going on at the internet level, there are very sophisticated techniques that can be used by malicious actors who have access to the internet itself. There are ways to fool the internet into thinking that something is what it isn't. And so I think there is a vulnerability still in that regard. But on the phone, what we've tried to do is to remove that possibility with iOS 8 and 9.
Thank you very much for all of you for your testimony.
Chair thanks the gentlewoman and recognizes the gentleman from Texas, Mr. Poe, for 5 minutes.
Thank the chairman. Thank you all for being here. Fascinating, important discussion on this issue of, as you say, security and security. As you know, I'm a former prosecutor and former judge, and dealt with warrants for 30 years, either at requesting them or signing them. And this particular case, I think we're really talking about two cases now. We're talking not just about the San Bernardino case, but the New York case as well. Different facts, different issues. Fourth Amendment we have discussed. Fourth Amendment doesn't really apply too much to this situation because the possession of the item is lawful in the possession of government. I do think it's ironic, however, we're talking about privacy. The United States is supposed to lead on the issue, I think, on the issue of privacy. We're the only one that has a Fourth Amendment. But we see that other countries seem to have more concern about privacy in their technology than maybe we do. I find that somewhat ironic. Let me ask you a couple of questions. You discussed the idea of constitutional right of privacy, but in one of your testimonies, and I think it was Mr. Nadler from New York, he and I have a language barrier problem, so I'm not sure I understood his question. You mentioned the First Amendment and the Fifth Amendment. Is that correct?
I did. That's correct.
Briefly explain how you see this as a First Amendment issue as well as a Fifth Amendment issue. We don't need to talk about the Fourth Amendment. We've discussed that.
The Fifth Amendment issue derives from the fact that we're being asked to write code. And code is speech. The Supreme Court has held that that speech is protectable. So we're being asked to speak by the government. That speech is not speech that we want to make. And the First Amendment provides us with protections against being compelled to speak by the government. So that would be the First Amendment argument in a nutshell. The Fifth Amendment provides us with protection from conscription, protection from being forced into labor at the government's will, except under the most extraordinary of circumstances, which I discussed with Congressman Issa. But that's the Fifth Amendment issue.
All right. Thank you. This request, the results of the request, how would that affect Apple worldwide in other countries?
Well, there are a number of parts of that question, Congressman, so thank you. The way that this would affect Apple is that it would affect our customers. It would affect everyone who owns an iPhone, and it would create a risk for everyone who owns a phone that their data could be compromised, that their security could be compromised. With respect to the international question, I agree with you. I think America should be leading on this issue, and I think that the world is watching what happens right now in our government and what happens even today with respect to this particular debate. Our ability to maintain a consistent position around the world, our ability to say that we will not compromise the safety and security of any of our users anywhere in the world is substantially weakened if we are forced to make that compromise here in our own country. So I urge this Congress, and I urge the government generally to understand and to take a leadership role. Give us the strong support that we need to resist any effort by other governments to weaken security and privacy.
One of the questions that was asked was talking about what is your solution, and I actually agree with Mr. Nadler. I know this is going to bother him a little bit, that there may be, after all this litigation, then there may be a solution that we haven't thought of yet, but would not one option be Congress taking the position that prohibits the backdoor key security system, the Viper system, as I call it, from...
Thank you, Mr. Poe.
I said that earlier, but you stepped out. But the Viper system from being imposed, required, prohibit that from government requiring that type of system in specific technology like an iPhone.
I think that is certainly one possibility, yes.
Prohibit the key. Let me ask you something else. If courts rule that you're required to develop the technology, develop the software, would that software be able to be used on all those other hundreds of phones that are out there that the government lawfully has in their possession but they can't get into?
Absolutely. There's nothing that would preclude it from being used on any iPhone that is in use today.
And my last question, would other countries then, if U.S. takes the position, thou shalt give government the key, what will other countries like China require or request or demand of Apple?
So to date, we have not had demands like that from any other country. The only place that we're having this debate is in our own country. But as I said before, I think if we are ordered to do this, it will be a hot minute before we get those requests from other places.
All right. Thank you, Mr. Chairman. I yield back.
Chair, thanks, gentlemen, and recognize the gentleman from Georgia, Mr. Johnson, for 5 minutes.
Thank you, and thank the witnesses for being here.
Mr. Vance, what's the difference between a company being ordered to use its best efforts? I think the language is, let's see, reasonable, a court order requiring reasonable technical assistance. What's the difference between a court order requiring reasonable technical assistance to accomplish the bypassing or disabling of the auto erase function versus a civil subpoena or a court order pursuant to a subpoena, a motion to compel the delivery of information under that person's custody and control? Is there a difference?
I'm not sure, Congressman, there is a difference. They're both court orders that are directing an end result. One maybe in a civil context, one in a criminal context. But I would say that in this discussion, it's very much a part of our history in America that when companies produce items or objects, or commerce becomes ubiquitous in a particular area, that the company has to have the realization that part of the group of people who are using its product are using it to commit criminal purposes. Take a look at banking system, currency transaction reports. So once it became obvious that criminals were moving cash through the banks, the response was you have to create and file transaction reports when cash is moved. So when two companies like these two hugely successful and important companies own 96.7% of the world's smartphone market, and we know that criminals are using the devices to commit crimes. We've heard some of those stories. I don't think that it is new in American history or in the context of business ethics or oversight for companies to have to adapt to the realities of the product they've created.
Because they are the only ones that can, a bank that received the cash would be the only entity in a position to submit a currency transaction report.
It would be the only one required to. If someone else had information about it, they could submit it, but it would be the only one who had firsthand knowledge.
Okay. Now, Mrs. Landau, is it your opinion that the government should not have the ability to compel Apple to use its best efforts to accomplish a technical feat? Is that your opinion?
So there are two answers to that. If you're asking me a lawyer question, then I'm not a lawyer and I'll dodge. But if you're asking me as a technologist, then I would say that it is a security mistake. It's a security mistake because
because what Apple would do would inherently cause a insecurity in their system.
That's right, and it will be the target of organized crime and nation states because it will be very valuable for somebody who puts a phone down as they go through customs, for somebody who goes to a business meeting and they're not allowed to bring their phone in because it's a meeting under non-disclosure and the phone is sitting outside for a few hours. All sorts of situations, the phone will become very interesting, and if there's code that can actually get into the phone and get the data, that code is going to be the target of nation states.
Once Apple creates the code, then it makes it susceptible to being stolen and misused.
That's right. That's right.
So
now,
therefore, Apple should not be required to comply with the court order.
I'm not answering a legal question. I'm answering a security question. It's a security question. It makes a real mistake.
Yeah. Okay. And Mr. Sewell, you would agree with that?
I would agree that if we're forced to create this tool, that it reduces the safety and security, not within our own systems, Congressman.
Well, now let me ask this question. What about the security and the safety of those whose liberty can be taken and lives can be taken due to an ongoing security situation
which the FBI is seeking to get access to information about. Is there an interest in the public security that we're talking about here?
Congressman, that's what...
The time of the gentleman has expired, but Mr. Sewell may answer the question.
That's what makes this such a hard issue, because we're balancing two different but very similar issues. Private security, the security of people who use iPhones, the location of your children, the ability to prevent your children from being kidnapped or harmed, versus the security that's inherent in being able to solve crimes. So it's about how do we balance these security needs? How do we develop the best security for the United States? If you read the statements by General, any of the encryption specialists today will say that defeaturing or debilitating encryption makes our society less safe overall. And so that's what we're balancing. Is it the right thing to make our society overall less safe in order to solve crime? That's the issue that we're wrestling with.
Thank you. I yield back.
The chair recognizes the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Thank you, Mr. Chairman. Mr. Sewell, you just mentioned the balancing. Can you give me a fact pattern where Apple would consent to the magistrate judge's order in California?
Congressman, we will follow the law. If we're ordered to...
No, I'm asking for a fact pattern. You mentioned balancing. I want you to imagine a fact pattern where you balance the interest in favor of what the Bureau is asking you to do as opposed to your current position. Give me a fact pattern.
Congressman, what I said was we have to balance what is the best security for the country, not balance when we should give law enforcement what they're asking, but balance what's the best security for the country.
I thought that's what we were balancing, is public safety versus privacy. You also mentioned the First and Fifth Amendment. Can you give me a fact pattern where Apple would consent to the order of the magistrate judge?
Congressman, what I said was privacy, security, personal safety.
Perhaps I'm being ambiguous in my asking of the question. Can you give me a fact pattern where you would agree to do what the Bureau is asking you to do in California, whether it be nuclear weaponry, whether it be a terrorist plot? Can you imagine a fact pattern where you would do what the Bureau is asking?
Where we would create a tool that doesn't exist in order to reduce the security and safety of our users?
Yes.
I'm not aware of such a fact.
So there is no balancing to be done. You have already concluded that you're not going to do it.
You know, I've said that we will follow the law. If a balance is struck, if there is an order for us to comply with, we will.
There is an order.
That order is being challenged at the moment as we speak. There's an order in New York that says...
I'm glad you mentioned the order in New York. That's a drug case. So you would agree with me the analysis in drug cases is very different from the analysis in national security cases. Even if you didn't agree with that, you would agree that in footnote 41, the magistrate judge in New York invited this conversation about a legislative remedy, which brings me back to Chairman Sensenbrenner's question. Where is your proposed legislative remedy?
So we don't have legislation to propose today, Congressman.
Well, then how will we know whether or not you think it strikes the right balance if you don't tell us what you think?
Congressman, when we get to the point where it's appropriate for us to propose legislation, not just Apple, but the other stakeholders that are engaged in this process, I'm sure there will be legislation.
Well, let the record reflect. I'm asking you for it now. I would like you to tell us what legislative remedy you could agree with.
I don't have an answer for you today. No one's had an answer for you today.
Can you give me one? I don't know whether Apple has lobbyists. I suspect you may have a government relations department, possibly. Can you submit legislation to Chairman Sensenbrenner's question that you could wholeheartedly support and lobby for that resolves this conundrum between you and the Bureau?
It is my firm belief that such legislation can be drafted. I do not have language for you today.
Well, but see, Mr. Sewell, we draft it, and then your army of government relations folks opposes it. So I'm just trying to save us time. The judge in New York talked about a lengthy conversation. Sometimes circumstances are exigent where we don't have time for a lengthy conversation. So why don't we just save the lobbying and the opposing of whatever Cedric Richmond or Hakeem or Louisa and I come up with? Why don't you propose it? Tell us what you could agree to.
Congressman, we're willing to, and we've offered to engage in that process.
What, the legislative process or the debate process?
Both, of course.
Will you submit legislation to us that you could live with and agree with?
If after we have the debate to determine what the right balance is, then I think that's a natural outcome.
Well, how long is the debate going to last?
I can't anticipate that, Congressman.
Well, let me ask you this. You mentioned the First Amendment, which I found interesting. Are you familiar with voice exemplars?
I'm sorry, is that a case, Congressman?
No. Voice exemplars are ordered by courts and judges for witnesses or defendants to actually have to speak. So a witness can see whether or not that was the voice that they heard during a robbery, for instance. How about, because you mentioned you have a First Amendment right to not speak, what about those who have been immunized and still refuse to cooperate with a grand jury, and they are held in contempt and in prison? So there are lines of cases where you can't be forced to speak.
Congressman, we've made an argument, a constitutional argument. If the courts determine that that argument is infirm,
I'm just asking you whether or not you agree that there are exceptions.
You've given me two examples that I've not heard of before.
All right, how about back to the Fifth Amendment, because I'm out of time. Real quickly, the Fifth Amendment, you say you're being conscripted to do something. But there's also a line of cases where folks are conscripted to perform surgical procedures or cavity searches or other things I won't go into in mixed company, where they are looking for contraband. So that's a nurse or a doctor or an anesthesiologist that is conscripted by the government. You would agree?
I'm not familiar with these cases.
All right, here's what I'll do. I'm out of time. I'll get you the cases I'm relying on if you'll help me with a legislative remedy. Deal?
I look forward to the cases.
Deal. Thank you.
The time of the gentleman has expired. The chair recognizes the gentleman from Florida, Mr. Deutsch, for 5 minutes.
Thank you, Mr. Chairman. I would start by saying this is really hard. I'm not looking to Apple to write the legislation to balance these very difficult issues between privacy and public safety. I don't expect you to do it. I expect us to grapple with it. And that's what we're trying to do here today. And I had raised this point earlier, but it's a perfect lead-in to the questions I want to ask. This focus on surgical procedures, and we can force the government can force a surgical procedure to be done, sounds like it's somehow equivalent. Well, certainly if we could do that, then we can require that a company create a way into its phone. Except, as I said earlier with Director Comey, that surgical procedure is going to be done by the person that the government says should do it, and there is no one from around the world who, from their remote location, is going to be able to figure out how to conduct surgery on that individual. Yet, in this case, and this is why this is so hard for me, in this case, there are people all over America and around the world who will be trying to figure out how to utilize whatever it is that's created here, if this is where this goes, to access the phone. And Director Comey earlier, Mr. Sewell, Director Comey said it's a three-step, he believes it's a three-step process that they're asking. Can you just speak to that process?
I absolutely can. Thank you, Congressman. First, I agree with you that this is not a problem which there are people that are trying to break into these systems. There are people who are trying to steal this information if it existed, and their capabilities are increasing every day. So this is not a threat which is static. This is a threat which is increasing. The three parts that we're being asked to develop are, first, a method to suppress the data deletion after 10 failed attempts. The second thing that we're being asked to suppress is the time delay between successive attempts. Both of these are specifically tailored to deal with the situation where your phone is stolen, where some bad person is trying to break into it, and it's specifically designed to defeat the brute force attack. Right. The third piece is interesting because the third piece is the government asking for us to rewrite the code that controls the touch screen and allow them to put a probe into the phone and to bypass the need to enter numeric digits through the touchscreen. The only reason that that makes sense, Congressman, is if you anticipate that this is going to be technology used on other phones and other phones that likely have more complicated passcodes.
Right, so that's the question. And Mr. Sewell, it's a question for you, and Mr. Vance, it's a question for you. This is one where if I understand that what's being asked of you is to create this way in to this one phone, then I want you to do it. I do. And I can get past a lot of these privacy issues if I believe that it's once in and this can then be disposed of, destroyed, and that'll be the end of it. The question is that the case? And when you create it for this one, is it something that can be used on other phones? Director Comey, I don't think, was clear about that. So I'd ask you that question, and Mr. Vance, I'd ask you the same question.
If I can refer to actually the doctor's own paper, you need the phone physically at Cupertino to open it. And I refer you to her
I don't have much time. I'm not sure that I understand what that means. I just want to know, let me just cut in the chase. I just want to understand if this is created, is it something that not just that could be used by you in the pursuit of justice, but by the criminal cyber terrorist hackers and really dangerous people who are looking to do bad things every day of the year going forward?
Congressman, my point is simply that if this code is created and you are looking at the risk to other devices, other Apple phones in the world, those phones are going to have to come to Cupertino to be opened. This is...
Well, let me ask Mr. Sewell then, before I only have a couple seconds left.
That's incorrect.
But the question is, even if that's correct, I'd like you to speak to it. Is it true that the hackers of the world, that there will be those who try to find a way to get around having to take the phone to Cupertino in order to conduct whatever operation is necessary to break in?
Yeah, unquestionably, Congressman, and that's exactly the risk and the danger that we foresee. With respect to the comment that Mr. Vance just made, in fact, the request that we got from the government in this case was that we should take this tool and put it on a hard drive and send the hard drive to the FBI. The FBI would then load that hard drive into a computer, hook the phone up to the computer, and they would perform the entire operation. So that this whole tool is transportable on a hard drive. So this is a very real possibility.
So shouldn't we be concerned, Mr. Vance? I mean, look, I want to get into this phone, but shouldn't we be concerned, if that's accurate, that there's something that's being created that's transported on a hard drive that winds up on another computer, that there is at least the risk that gets stolen, and suddenly there is not just a bad person and these terrorists that we desperately want to get and get this information, but suddenly all the rest of us who are trying to protect ourselves from the bad people and who are trying to protect our kids from these bad people are potentially at risk too.
Congressman, I respectfully disagree with the colleague from Apple, but I will confess that his knowledge of the company is great. Apple has created a technology which is default disk encryption. It didn't exist before. It exists now. Apple is now claiming a right of privacy about a technology that it just created. That right of privacy didn't exist before Apple created the technology, number one. Number two, I can't answer how likely it is that if the federal government is given a source code to get through the front door of the phone, that is at risk of going viral. I think it may be overstated to suggest that, but I can tell you this. if there's an incremental risk that providing the source code creates a vulnerability, what is that risk? Don't tell us just millions of phones might be affected. Tell us, I think we can do better than just giving us broad generalizations without specifics. But I can tell you this, the consequence, the other side of the weight, the consequence is in cases all over the country right now, in my jurisdiction, your jurisdiction, everywhere, families like the Mills family are not getting justice. And the direct consequence of this disk encryption is that innocent victims all over the country are not getting their cases solved. Prosecutors are not doing the job that they have been elected and sworn to do. And there is a significant consequence to default disk encryption that I think needs to be balanced against a speculative claim of increased insecurity.
I'd like to just add a couple of comments. This is not about a new right of privacy. It's about a new form of security. And if we think about how the phones are used, and increasingly how the phones are used, I certainly have two-factor authentication I use through my phone, but there are ways of using the phones as the original authentication device. And if you make the phone itself insecure, which is what is being asked for by law enforcement, you preclude that. And that is the best way to prevent the stealing of login credentials, the use of a phone as authenticator. In terms of the risk of the disk and so on, it's not the risk of the disk going out because the disk is tied to a particular phone. The risk is that somebody will come into Apple and provide a rogue certificate that they're from law enforcement or wherever, and will get the ability to decrypt a phone that should not be decrypted, whether it's the Chinese government or an organized crime group or whatever. That's the risk we're facing.
May I, Congressman, with the chairman's permission?
My time is up. The chairman's been very generous.
Well beyond the time, but briefly.
The professor has not answered. What about the people, the residents, the citizens, the victims, whose cases are being put on the side and not addressed while we have an academic discussion, an important one?
Well, it's an important academic discussion because before these phones existed, the evidence that you're talking about didn't exist in the form that you've had access to. Now the technology is moving to a new generation, and we're going to have to figure out a different way to help law enforcement. But I don't think we say we're not going to ignore these vulnerabilities that exist in order to not change the fact that law enforcement is going to have to change the way it investigates and gathers evidence. The time of the gentleman has expired. The chair recognizes the gentleman from Illinois, Mr. Gutierrez.
Thank you, Mr. Chairman. First of all, I'd like to ask through the chair if Congressman Loughran has a need for any time. I'd like to yield to her first before my interview.
Well, I thank you very much. You know, I don't know you, Mr. Vance. I'm sure you're a great prosecutor. I do know Mr. Sewell. He's a great general counsel. But the person who really knows technology on the panel is Dr. Lando. And I'm interested in your comments about the vulnerabilities that would be created by complying with the magistrate's order. And some have suggested that it's speculative and academic and the like. But is that what your take on this is?
Absolutely not.
The theory, I mean, we're moving to a world where everything is going to be digital, and you could keep track of, when I'm walking around the house I'm in, my temperature, opening the refrigerator, driving my car, and if that all is open to a legitimate warrant. I'm not downplaying the problem that prosecutors have, but this is evidence you currently don't have access to. How vulnerable are is our country going to be? That's the question for you.
Extremely vulnerable. David Sanger's article in today's New York Times about the Ukraine power grid says that they got in, as I mentioned earlier, through the login credentials. It's based on a DHS memorandum that talks about locking down various systems. I served for a number of years on NIST's Information Security and Advisory Security and Privacy Advisory Board, and we used to talk to people from the power grid, and they would say, "Oh, it's okay. Our systems aren't connected to the internet." Well, they were fully connected. We are, whether you're talking about the power grid, the water supply, whatever, we're connected in all sorts of disastrously unsafe ways. And as I mentioned earlier, the best way to get at those systems is through login credentials. Phones are going to provide the best way to secure ourselves. And so this is not just about personal safety of the data that all of you have on your phone, and it's not just about the location of where your family is, and it's not just about the business credentials, but it's really about the, as you say, Congressman Lofgren, it's really about the way we are going to secure ourselves in the future. And what law enforcement is asking for is going to preclude those strong security solutions. It also is a very much a 20th century way of looking at a 21st century problem. And I didn't get a chance to answer Congressman Gowdy, but the FBI, although it has excellent people, it hasn't put in the investment. Director Comey said, we talk to everyone who will talk to us, but I was at a meeting, I briefed at FCC a couple of years ago, and some senior people from DOJ were there, and I said, well, you know, NSA has skill X and skill Y, and DOJ said, they won't share it with the FBI except in exceptional circumstances. They keep it for themselves. We're in the situation where I think law enforcement needs to really develop that skills, those skills up by themselves. And then you ask about what it is this committee can do. It's thinking about the right way for law enforcement to develop those capabilities, the right level of funding. The funding is well below what it should be, but they also don't have the skills.
Thank you. So I'm happy I yielded the time to you. I always know it's one of the smartest things I do is work with Congresswoman Lofgren in this committee. But I just want to share with you, look, I understand the competing interests here, but I think, Mr. Sewell, you should understand that I love your products. You know, I used to think, you know, a house, then a car. Now I think technology. Between what they charge me for the internet, and all the stuff I buy just to get information every day, it's, but don't worry, I can afford it. I'm not going into the poorhouse because of it. So I'm excited about all of the new things that I get to and how it improves my life. And so I'm thankful to men and women in technology for doing that. But a lot of times in this place, there's adversarial positions taken, and I would hope simply that we would look for a way in which we put the safety interests of the American people. I understand that you think that if we find a back door, that causes all kinds of insecurities. But in this committee, I'm going to work with Congresswoman Lofgren, but I'm also going to work with Trey Gowdy. We're going to work. A lot of times bipartisanship in this place is many times promoted, but very, very rarely rewarded in this place because everybody says, oh, you should take one position or another. I'm going to take a position for the American people. While you might dispute, I kind of look at Apple as an American company. Look at Toyota as a Japanese country, BMW as a German. I look at you as an American company. And so that's the way I see you. You can dispute that. You may look at yourself as an international entity, but I always looked at you as the pride. When I take this phone as a member of the Intelligence Committee and I take this phone to China, the intelligence community of the United States of America, the first thing before I get off that plane is they take it away from me. So there are bad actors out there already intervening with your products, or I don't think the fine people of the intelligence community would take away one of the things that I need the most in my life. So having said that, I hope we might find a way so that we could balance the security needs and the safety needs of the people of the United States and their right to privacy. I think it's essential and important. And I want to thank you guys for coming and talking to us, and let's try to figure it out all together. Thanks.
Thank you, Congressman, and I absolutely, I agree with what you said, and I think that I am proud to work for Apple, and I think Apple embodies so many of the most valuable characteristics that make up America, make America a great place. We stand for innovation. We stand for entrepreneurship. We stand for empathy. We stand for all boats rising. So I'm very proud, and we are an American company, and we're very, very proud of that. The point about security outside of the United States is exactly the point that drives us. We are on a path to try to create the very best, most secure, and most private phones that we can. That's a path that will probably never end, because the people that we're competing with, the bad guys, not just in the United States, but all over the world, are on an equally aggressive path to defeat everything that we put into the phone. So we will continue from generation to generation to improve the technology and to provide our users with a safer experience.
Thank you, Mr. Chairman.
The gentleman from Louisiana, Mr. Richmond, is recognized for 5 minutes.
And I'm happy to follow Luis, because I guess we're going to start, I'll start where he left off. And I think about a 9-year-old girl who asked, you know, why can't they open the phone so we can see who killed my mother? Because I was there and heard it happen. So let me start with this. If the FBI developed the ability to brute force open a phone, would you have a position on that?
Without involving Apple, without having Apple be implicit in that, I don't think we have a position to object or not object to that. I think if the FBI has a method to brute force a phone, we have no ability to stop them.
But are you okay with that?
Well, I think that privacy and security are vitally important national interests. I think that if you weaken the encryption on the phone, then you compromise those vitally important interests.
I'm not asking you about the encryption. If they could brute force open a phone, do you have a problem with that? I think that's just an easy question.
I'm sorry, perhaps I'm misunderstanding. If the FBI had the ability to brute force a phone, I would suggest that that's a security vulnerability in the phone. So I would have a problem with it, yes.
Let me ask you another question, because I see you're a lawyer, I'm a lawyer, and I would feel awful if I didn't ask this. Brittany Mills.
Can I just say something for a second?
In a second, let me get through this question. Brittany Mills had a 5S phone operating on a 8.2 iOS. Does Apple, any employee, subcontractor, subsidiary, or anyone that you know of possess the knowledge or the ability to open that phone or unlock that phone?
We don't, and I'm glad that you asked about the Mills case, because I think it's instructive about the way that we do work together cooperatively. I know that we met with members of your staff.
Look, and I'm not suggesting that you all don't, but I just want to know, does anybody have the ability to unlock the phone first? And if you tell me no, then I get a no in public, on the record, and I feel a lot better about what I'm doing.
Let me be clear. We have not said that we cannot create the tool that the FBI has asked us to create.
Right. No, I'm not asking about creating anything. I'm saying, does it exist now? Do you know anybody, or does anyone have the ability to do it right now?
Short of creating something new, no.
Now, I'm sorry, Ms.
I just wanted to add that in security we have an arms race. People build good products, somebody finds a vulnerability. It could be the FBI, it could be, now the FBI may not tell anybody about the vulnerability, but we have this arms race where as soon as somebody finds a problem, the next roll of technology comes out. And that's the way we do things.
So what would be your feeling if the FBI developed the technology that they can plug something into the iPhone?
I think that the FBI should be developing the skills and capabilities to do those kinds of investigations. I think it's absolutely crucial, and I think that they have some expertise, but it's not at the level that they ought to have. And I think we're having this conversation exactly because they're really using techniques they're using a mindset from long ago, from 20 years ago, rather than the present.
So they're antiquated.
Would the gentleman yield?
Sure.
I just want to clarify, both Mr. Sewell and Ms. Landau did not say subject to an authorized court-ordered warrant.
Well, I certainly meant subject to
You're not suggesting they develop this technology and then do what they think is best. They've got to do it subject to a warrant.
Of course. Thank you.
And I'm glad you cleared that up, because I want to make sure that everybody understands what I'm saying. I don't think any of this should happen without a court order. Now,
you know, maybe I watch too many movies and maybe I listen to Trey Gowdy too much. Some people would suggest if I listen to him at all, that's too much. But in the instance that there's a terrorist that has put the location of a nuclear bomb on the phone and he dies, how long would it take Apple to develop the technology to tell us where that nuclear bomb was? Or would Apple not be able to develop that technology to tell us in a short period of time?
The first thing we would do is to try to look at all of the data that surrounds that phone. There is an enormous change in the landscape over the last 25 years with respect to what law enforcement has access to. So when we have an emergency situation like that, whether it be a lost child or the airplane, when the Malaysia airline went down, within 1 hour of that plane being declared missing, we had Apple operators cooperating with telephone providers all over the world, with the airlines and with local law, well, with the FBI, to try to find a ping, to try to find some way that we could locate where that plane was. So the very first thing that we would do in this situation is to bring to bear all of the emergency procedures that we have available at Apple to try to find that.
Thank you. Mr. Chairman, can I just clarify, because I don't want anyone to leave out of here thinking that Apple has not been cooperative with our district attorney in the effort to access the data. And in fact, they came up with new suggestions. But my questions are just about the government's ability to just brute open a phone at any point with a court order. So I don't want to suggest that Apple has not been working diligently with my DA, who's also been working diligently. So thank you, Mr. Chairman. I'll yield back.
I appreciate that, Mr. Congressman.
Sure. Thanks, gentlemen. Recognize the gentlewoman from Washington State, Ms. Delbene, for 5 minutes.
Thank you, Mr. Chair, and thanks to all of you for being here and for enduring this for a while. It's very, very important. In the earlier part of the hearing, Director Comey said that it is not a company's job to worry about public safety, and I think that would be very concerning for a company to send that message, given that we have technologies that impact people's everyday lives in so many ways, and I assume you agree with that, Mr. Sewell.
I absolutely do. I do not subscribe to the position articulated by Director Comey.
I worked at 2 Silicon Valley companies, Sun Microsystems and Google, and that's certainly not what I saw at either one of them.
In the Brooklyn case decided yesterday, Judge Ornstein stated in his opinion that the world of the Internet of Things, all of the connected devices and sensors that we see coming forward, the government's arguments would lead quickly to a world of virtually limitless surveillance and intrusions on personal privacy. So I'd like to explore the issue of encryption and securing the Internet of Things a little bit. We often talk about security by design when it comes to the Internet of Things. And I'm sure we can all imagine the horror stories of insecure Internet of Things types of devices, like appliances being hacked to cause a fire, or spying through baby monitors, hacking into a car, or tampering with a home security system. So I'm wondering, Dr. Landau, I'm wondering if you could comment on what this means in the encryption context, and whether directives we've heard from the FTC, for example, to adopt security by design in the interests of protecting consumers from malicious actors is inherently incompatible with what you might call insecurity by design. Should that be mandated by the courts?
Well, here you're in a situation where the companies often want to collect the data. So for example, if you're using smart meters, the company wants the data, the electric company wants the data to be able to tell your dishwasher, no, don't turn on at 4 in the afternoon when air conditioning requirements are high in Silicon Valley right now. Turn it on at 8 at night or 2 a.m. And so, in fact, it actually wants the individualized data, and if it has the individualized data, then it can certainly share it with law enforcement under court order. The security by design is often in the Internet of Things, securing the data on the device and securing the transmission of the data elsewhere. The issue on the Apple phone is that the data stays on the device, and that's the conflict that we're having. For the Internet of Things, it's most useful if the data goes off the device to somewhere else where it can be used in a certain way.
And Mr. Sewell, could companies open themselves up to liability if vulnerabilities for law enforcement end up being exploited by a bad actor?
think that's absolutely true. Somewhat ironically, I suppose, we have the FTC at this point actively policing the way in which technology companies deal with these issues, and we can be liable under the Section 5 or under the authority of the FTC if we fail to close a known vulnerability.
And Ms. Landau, you talked about the question of security versus security, or the issue of security versus security, and that this really is a debate about security versus security. Could you explain a little bit more why, and are national security and cybersecurity incompatible in your opinion?
So what we really have here over the last 20 years, as I mentioned earlier, is you see the NSA, and Snowden revelations aside, we don't have time for me to describe all of the subtle points there, but you really see the NSA working to secure private sector telecommunications infrastructure. Many, many examples. We have moved to a world of electronic devices, you talk about the Internet of Things, that leak all sorts of data. And in order to protect ourselves, whether ourselves, our health data, our bank data, the locations of our children, and so on, we need encryption and so on. But if you think more broadly about the risks that our nation faces, and the risks of people coming in and attacking the power grid, people coming in and stealing data from whatever company and stealing patent information and so on, you see a massive national security risk. And you've been hearing it from General Keith Alexander, we've been hearing it from Hayden, we've been hearing it from Mike McConnell, we've been hearing it from Chertoff, all the people who've been involved on the DHS and NSA side. The only thing that can secure that is security everywhere, and the move that Apple makes to secure the phones is one of the many steps we need in that direction.
Thank you. My time's expired. I yield back, Mr. Chair.
Thank you. And I'm going to recognize myself for some questioning. So welcome, everyone. I'm sorry, Mr. Sewell, pronouncing that name correctly.
You are.
All right. I have some questions for you concerning China. In 2014, you moved what's referred to as your Chinese cloud to China. Is that correct?
That is correct.
Okay. And can you tell me whose data is stored in that Chinese cloud? Is it just people in China? Is my data stored in that cloud as well?
Your data is not stored in that cloud.
Is it strictly limited to Chinese people?
There are a number of things that are in the cloud, so I should probably be clear about what's there.
Okay.
With respect to personal data, no personal data is there unless the individual's data, the individual himself has registered as having a Chinese address and having a Chinese access point. In addition, we have other data which has to do with film content, movies, books, iTunes music. The reason we do that is because of something called latency. If you're streaming across the internet and you have to bring the data from the United States to China, there's a lag time, there's a latency piece. Yep. Whereas if we move that data closer to China, either Hong Kong or mainland China, then we can provide a much better service to our customers.
Okay. Can you tell me what was the cost in the ballpark figure and the time to make the move from the United States to move Chinese information over to China in their cloud?
I'm sorry, did you say in time?
Yeah, cost and time.
So the time, the cost is in building the facilities. I don't have a number for that. It's certainly not something that I'm aware of, although, of course, the company has that information. In terms of the time, once the server exists, once there is a receptacle for the data, in theory, it's instantaneous.
Okay. You may or may not know, but I was a prosecutor for a while, both at the state and federal level. And we prosecutors are focused on a case and the crime concerned, and we want to get our hands on anything we can to see that justice is served. But on the other side of this, too, we're talking about privacy issues. And I'm very concerned about to what extent, if for some reason you were to change your mind about working with the FBI or the court ordered that, what does that mean to our privacy?
I think it means that we have put our privacy at risk. The tool that we're being asked to prepare is something which could be used to defeat both the safety and the privacy aspects of the
Let me get this clear, because there are many rumors flying around, and you probably answered this a couple times, and I apologize. I've had to run and do something else. Are you saying that there is no method that exists now that you could unlock that phone and let the FBI know what is in there?
Short of creating the tool that they have asked us to, we are not aware of such a method. No.
Now, you talk about the cost is an unreasonable burden and the time involved. That's why I ask you, what did it cost to move the cloud? What was the time? And you're the expert, I'm not.
Congressman, to be fair, we haven't claimed that the time that it would take to create the tool is the undue burden. Our claim is that the undue burden is to compromise the safety and security of all of our customers.
So it's your position that if you do what the FBI wants to one phone, could you elaborate on that in the 33 seconds I have left as to why that would be an undue burden, keeping in mind that I'm very critical about our privacy?
Congressman, the answer is very simple. We don't believe this is a one-phone issue. We don't believe that it can be contained to one phone or that it would be contained to one phone.
Okay, I see that my time is just about run out, so I'm going to yield back. And who's next? Mr. Jeffries, Congressman Jeffries is next.
Thank my good friend from Pennsylvania for yielding. I want to thank all of the witnesses for your presence here today. It's been a very informative discussion. In particular, I want to thank DA Vance for your presence, and certainly for the many progressive and innovative programs that you have in Manhattan, proving that you can be both tough and fair as a prosecutor, and that has not gone unnoticed. Let me start with Mr. Sewell. There's an extensive record of cooperation that Apple has with law enforcement in this San Bernardino case. Isn't that fair to say?
That's correct. For over 75 days, we've been working with the FBI to try to get to more information and try to help solve this crime.
I think it's useful to put some of this on the record. On December 5th, the Apple Emergency 24/7 call center received a call concerning the San Bernardino shooting. Is that right?
That's right. In fact, the call came in to us at 2:47 a.m. on a Saturday morning. We have a hotline that exists. We have people who are manning that hotline.
And you responded with 2 document productions that day, correct?
By 2:48 that morning, we were working on the case, and we responded by giving the FBI all of the information that we could immediately pull from our sources, and then we continued to respond to subpoenas and to work directly with the FBI on a daily basis.
Right. In fact, the next day, I think Apple received a search warrant for information relating to at least 3 email accounts. Is that right?
That's correct.
And you complied with that request?
We did comply with that and subsequent requests.
And so I think also on January 22nd, you received another search warrant for iCloud information related to the iPhone that was in possession of the male terrorist. Is that right?
That's right, and it's important that in the intervening stage, we had actually sent engineers to work directly with FBI technicians in Washington, D.C. and in Cupertino. And we provided a set of alternatives or options that we thought should be tried by the FBI to see if there might be some possibility that we could get into this phone without having to do the tool that we're now being asked to create.
So the issue here is not really about cooperation, as I understand it. Apple has clearly cooperated in an extensive fashion as it relates to all of the information that you possess. The question I think that we all on the Judiciary Committee and beyond have to consider is the notion of you being asked as a private company to create anti-encryption technology that currently does not exist and could jeopardize the privacy and security of presumably hundreds of millions of iPhone users throughout the country and the world. Is that right?
Yeah, we're being asked to create a method to hack our own phones.
Now, Mr. Vance, are you familiar with the Arizona v. Hicks Supreme Court case from the late 80s?
if you give me the facts, I'm sure I've read it.
Okay, well, the Supreme Court held that the police conducted an unconstitutional search of evidence that was not in plain view. It was a decision that was written by Justice Antonin Scalia. And the most important point that I want you to reflect upon is he stated, in authoring the majority opinion, that there is nothing new about the realization that the Constitution sometimes insulates the criminality of the few in order to protect the privacy of us all. Do you agree that embedded in the fabric of our Constitution, the Fourth Amendment and beyond, is the notion that we value the privacy rights of Americans so deeply that at times it is something that will trump law enforcement convenience?
Congressman, I do sincerely believe that. What concerns me about the picture we are seeing from the state perspective is that Apple has decided that it's going to strike that balance now with no access by law enforcement for full disk encrypted devices, even with a warrant. So they have created their own balance. They now have decided what the rules are, and that changes radically the balance that existed previously, and it was done unilaterally. So this
well, I think if I can just interject, I mean, I think that that's a balance that ultimately the Congress is going to have to work out, and also the Article III court system, certainly beyond an individual magistrate who's not even appointed for lifetime tenure. This is going to have to work itself through the court system, a district court judge, maybe the Ninth Circuit, ultimately the Supreme Court. And so the company exercising its right in an adversarial system to have all facts being aired on both sides of the debate is very consistent, in my view, with American democracy and jurisprudence. Just one last question that I wanted to ask as my time is expiring, because you raised an interesting point earlier in your testimony about an individual who is a suspected criminal who claimed that the encryption technology was a gift from God. But I also noted, I think, in your testimony that this individual communicated that in an intercepted phone conversation that presumably your office or others were wiretapping. Is that right?
No, it's not right. All phone calls from prison out of Rikers are recorded.
Right.
And there's a sign when you pick up the phone, if you are in Rikers Island, that this is happening. So there's a tape. And ultimately that tape was subpoenaed, and it's from that tape that that conversation was transcribed.
And if I could just, in conclusion, I appreciate the chair's indulgence, I mean, I think that illustrates the point, presumably, that it's fair to say that in most instances, bad actors will make a mistake. And at the same time that he's heralding the availability of encryption technology to shield his activity from law enforcement surveillance and engagement, he's ignoring a plain view sign that these conversations are being recorded and subjecting himself to unfettered government surveillance. And I think that I have faith in your ability, in the FBI's ability, ultimately to outsmart the criminals and the bad actors without jeopardizing the privacy and the security of the American people.
And in that case, our challenge is because of our inability to access the phone, our inability to investigate further any evidence of sex trafficking is not made available to us. So yes, he did something that was not smart, but the greater harm is the inability, in my opinion, of being able to get to the true facts, which in fact are extremely important as a matter of public safety to get access to.
My time has expired. I thank you.
I thank the gentleman from New York, and the chair recognizes now the gentleman from Rhode Island, Congressman Cicilline.
Thank you, Mr. Chairman, and thank you to our witnesses for your testimony and for this very important discussion. I think we all recognize there are few absolutes in the law, and so balancing occurs all the time. There are risks in developing the software that have been articulated very well during this hearing. And indeed, there are risks associated with an inability to access critical information. So I think we are living in a world where there are risks in both ways forward. And I guess my first question is, many people who agree that Apple or any other company should not be required, and there's no authorization to require them to produce a product that doesn't exist or to develop intellectual property that doesn't exist. Many people who think that that's correct wonder whether Apple has considered, in limited circumstances, and maybe a standard you would set internally, if it in fact is a situation that would prevent immediate death or serious bodily injury, coupled with a consent of the person or lack of objection, in this case a person who's deceased, where there's no privacy claim asserted, in some very narrow category, whether there's a set of protocols you might voluntarily adopt to provide that information or that software with then instructions that it be immediately destroyed, it be done in a SCIF, in a secure state. I mean, is that practical, something like that? Should that be part of this discussion that we keep hoping that the industry and the Justice Department will have in trying to develop something, or is that fraught with so many problems that it's...
Thank you for the question, Congressman. We have and spend a lot of time thinking about how we can assist our customers in the event that they have a problem. If they've lost a phone, if they're in a situation where they're trying to recover data. We have a number of mechanisms to do that, and we will continue to improve those mechanisms as we move forward. It's very important to us that we try to think about the consequences of the devices that we create. In this particular case, the passcode unlock is not something that we think lends itself to a small usage. The problem with this particular issue is that once you take that step, once you create the mechanism to unlock the phone, then you have created a backdoor. And we cannot think of a way to create a backdoor that can only be used beneficially and not be used by bad people.
So you have, in fact, sort of already contemplated other ways in which you could make this information available in this case that would not have those sorts of broader implications?
And we have provided information in this case. We have provided logs, we have provided iCloud backup, we've provided all the things that we have at our disposal.
Thank you. Professor Lano, you say in your written testimony, the point is that solutions to accessing the data already exist with the forensic analysis community. We did ask Director Comey, and we probably limited our question too narrowly because we asked about the intelligence communities of the United States. It sounds like you're suggesting that there may be capabilities outside the United States government that the Justice Department or the FBI could contract with that are capable of doing what it is they're asking a court to order Apple to do.
That's right. So I noticed that when Director Comey answered the question, he said, we talk to everyone who will talk with us. And as I mentioned earlier, I don't know if you were here at that point, I had a conversation with some senior DOJ people a few years ago about using NSA tools in law enforcement cases, and they said, NSA is very loath to share because, of course, when you share a tool, it can get into a court case, and then the tool is exposed. And so I don't know, we talked with everyone who will talk with us, how much NSA revealed about what they know and what they can do. So that's the first place I would ask. Now, I phrased that incorrectly. That's the first place that I suspect has some tools for exactly this problem. But yes, there were discussions last week in Silicon Valley. There have been discussions I've had with colleagues where people believe, as Congressman Issa portrayed various potential solutions, that there are ways to break into the phone. There is, of course, a risk that the data might be destroyed. But I have described, both in my written and verbal testimony, the FBI has not tried to develop this level of expertise, and it should.
So it seems as if, we're contemplating whether or not Congress should take some action to either grant this authority and then figure out what is the appropriate standard and test, et cetera. It sounds as if you think that is problematic, and that, in fact, the real answer is a substantial increase in investment in the intelligence capability, the law enforcement capabilities to sort of keep pace with the advances that companies like Apple are making, that's really the best protection in terms of both law enforcement and the long-term security of the United States.
That's right. I don't think actually there needs to be more authority, but there needs to be a completely different view of how it's done. There probably needs to be some authority in terms of how do you handle it for state and local, because state and local will not have the resources. And so there has to be some sort of sharing of tools, and that's a jurisdictional issue and also just an issue between bureaucracies that'll have to be worked out, and that'll have to work out through law and policy. But in terms of creating new authority, the FBI already has that authority, but it uses it at a much lower level than it should. It's funded at a much lower level. They need to move from the situation they're in to dealing with 21st century technologies in the appropriate way.
Thank you. Thank you, Mr. Chairman. I yield back.
Okay. You bet. Chair recognizes California.
Could I ask just one quick question, Mr. Sewell, because I forgot when it was my turn. And we had asked Mr. Comey, somebody asked Mr. Comey about the changing of the password. Apparently the county did it at the request of the FBI. What did that do? Can you explain what happened?
Certainly. One of the methods that we might enable the phone in San Bernardino to do what's called an auto backup. That is, the issue that the FBI is struggling with is to find data between a certain time frame, the time of the last backup and the time of the horrific incident in San Bernardino. If the phone would back up, that evidence, that information would become available to the FBI. The way that we can back these phones up in an automatic way is we connect them to a known Wi-Fi source, a source that the phone has already connected to before and recognizes. If you plug the phone in and you connect it to a known Wi-Fi source, it will, in certain circumstances, auto backup. And so the very information that the FBI is seeking would have been available, and we could have pulled it down from the cloud. By changing the password, this is different than the passcode, but by changing the password, it was no longer possible for that phone to auto backup.
Thank you, and thank you, Mr. Chairman, for letting me get that information out.
Mr. Sewell, I have one more question for you. Does the Chinese government have access to the cloud, or is there any indication that they've tried to hack the cloud in China to get information on the Chinese people?
Let me be clear about the question. The Chinese undoubtedly have the ability to access their own cloud.
Yes.
But with respect to the U.S. cloud, we believe that, again, I'm struggling because of the words. The cloud is a synonym for the internet.
Yes.
So of course Chinese people have access to the internet. Are we aware of a Chinese hack through Apple? No.
Okay.
But beyond that, I can't say.
Okay. You answered my question. Thank you. This concludes today's hearings. I want to thank the panel very much for being here. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. The hearing is adjourned.
Good to see you. Nice to see you.
A nearly 5-hour hearing wrapping up on the House side of the U.S. Capitol, a House looking in particular at the FBI's request to unlock the smartphone used by the San Bernardino terrorists. The Justice Department has argued that the request is limited in scope and is necessary because it's been unable to unlock the phone used by Syed Rizwan Farouk, who, along with his wife, killed 14 people and injured nearly 24 in a shooting rampage in December in San Bernardino. I want to let you know that we will re-air this entire hearing tonight beginning at 9:15 Eastern on our companion network C-SPAN 2, and you can also find it online anytime at cspan.org. Well, it is Super Tuesday. Primaries and caucuses across the country in 12 states.